in Virginia.
Marianne, we broadcasting? Oh, excellent. Okay, good. We're in business. All right. Welcome to our, second or third to last Courts of Justice Committee meeting. We've got about 40 bills and 35 bills in the docket today, maybe. First of all, House Bill 794, without objection, will go by for the day. That's Delegate Henson. He has to go get us some answers on that. We have 5 cognates, and then a whole bunch of new bills we have to crank through today. And I think we've got the sign-up sheet programmed in. But first, I want to take care of the cognates first, and then we will jump to the sign-up list and the new bills. So, first of all, if everybody could turn their attention to House Bill 36 by Delegate Willett. That is the cognate for Senate Bill 44 by Senator Van Valkenburg. It has to do with abuse and neglect, children gaining access to firearms. The bill is identical to Senator Van Valkenburg's bill that we've already passed. So Senator Deeds moves, Senator Boysko seconds that we report and refer the bill to Finance. Is everybody ready?
I think there are no proxy buttons open. Go ahead.
You got the proxy enabled, MJ? Okay, clerk will open the roll.
Guys?
Ayes 10, noes 2.
You're right.
Okay, thanks, MJ. Next up, we have House Bill 175 by Delegate Simon. This has to do with carrying assault firearms in public. It's similar to Senate Bill 99 by Senator Eben. We have a conforming sub with an additional change. So Senator Deeds moves, Senator Boysko seconds that we conform the bill with the additional change. And I'll clerk counsel explain it in a minute. All those in favor say aye. Aye. Anybody opposed? No. Okay. Counsel, can you explain what the one additional change is that makes it different from what we already voted on?
Yes, Mr. Chair. The one change that was not in Senate Bill 99, which is in it now as it passed the House, is that it provides an exception for cadets who are recognized by public institution of higher education while they're engaged in training or ceremonial events.
All right. Can't have cadets carrying guns.
Move the report,
I guess you overruled me. Okay. It's been moved that we refer the bill to Finance. The clerk will open the roll.
Ayes 8, noes 4.
The bill reports refers to Finance.
Did you say I did proxy McDougal?
Yeah, I did. All right, next up, we have House Bill 318 by Delegate Helmer. This has to do with civil liability for firearm violence in the firearm industry. It is similar to Senate Bill 491 by Senator Carol Foy, and we need to conform the bill.
We conform the bill.
Deeds moves, Boysko seconds, we conform. All those in favor say aye. Aye. Anybody opposed?
Report and read for the Finance.
It doesn't need to go to Finance. So Senator Deeds moves, Boysko seconds, the bill be reported. Clerk will open the roll.
Ayes 8, noes 5.
Bill reports. Next up, we have House Bill 362 by Delegate McClure. This has to do with, I believe, closing the boyfriend loophole, so-called. It's similar to Senate Bill 642 by Perry.
We conform the bill to 640.
There's a conforming sub that has one additional change. I'll have counsel explain. Deeds moves, I think, Boysko seconds. Do we conform it? All those in favor say aye. Aye. Anybody opposed? No. Counsel, can you explain the one additional change?
Yes, Mr. Chair. The one additional change is that it also adds an individual who cohabits or who within the previous 12 months cohabitated with the person to the definition of family or household member that's used for the purposes of the prohibition on possessing a firearm after conviction of assault and battery of a family household member.
I move the report and refer to Finance.
Okay, any other questions? Okay, Senator Deeds moves, Boysko seconds, the bill be reported, referred to Finance. Clerk will open the roll. And then last up,
Ayes 8, noes 5.
sorry, thank you, MJ. Last up is a little bit of a twist here. This is House Bill 1324 by Delegate Fowler. This is not a bill that we heard in this committee, but is identical to Senate Bill 6, which Senator Reeves reported out, that I thought about actually pulling in here so we could take a look at it, but it passed out unanimously. This has to do with shortening the period of time to obtain a restricted driver's license if you're convicted of certain DUIs and you go through a treatment docket. I'm not sure if you all want to take any testimony on it, but it did pass the Senate unanimously already, and it's identical. Everybody good?
You want us to pass it? Yes, sir.
Shocker. Nobody wants to ask any questions? Okay. All right, it's been moved. I think Peak moved and Stanley second. The bill be reported, and I don't think it needs to go to finance. So, clerk will open the roll.
Ayes 13, no zero.
I'm assuming the transportation chair doesn't want the bill that went through her committee. Doesn't look like it. No problem. Okay. All right, now that brings us to new bills. And I have, for everybody's planning purposes, Watts, Cherry, Helmer, Srinivasan, Kent, and Simon, and another 9 after that. So why don't we go with, let's go with Delegate Watts first. Delegate Watts, you have a robbery one, and is that your only one? Okay.
HB 77.
HB 77, and I believe do you have a sub?
I have a major sub, yes.
All right. Senator Deeds moves, Boyce goes second. The substitute, all those in favor say aye. Aye. Anybody opposed? No. All right. We have a sub before us.
Thank you, Mr.
Delegate Watts, why don't you explain this sub to us?
Yes, thank you, Mr. Chairman. I said it was a major sub because I have been extremely grateful in this area that counsel from both the House and Senate have sat together, and I really appreciate Mr. Benjamin, Ms. May, Mr. Mutnick, and Mr. Hatcher all sitting together and scrubbing every aspect of this bill to make sure that there are comparable reflections of what is in each section with the 4 classes of robbery that were established in 2021. I need to say very briefly what those 4 classes are. Up until 2021, robbery was a single charge with a sentence up to 40 years. There's no place else in the criminal code where we have that kind of single charge. Therefore, there were many different circumstances, and what really took me by surprise was that when I looked at the prison population, we have more people in prison on robbery charges than all drug charges combined, and that's partly because of this up to 40 years on a single charge. Thank you. I'm being corrected by Mr. Benjamin, up to life. I've always said up to 40 years. Thank you. So this then is what was addressed in 2021, establishing 4 different degrees of robbery. One being serious bodily injury or death, and that's a Class 2 felony. 2 being using or displaying a firearm and in a threatening manner is a Class 3 felony. 3 is the use of physical force not resulting in serious bodily injury or by using or displaying a deadly weapon, and that's a Class 5 felony. And the 4th one is a person who commits robbery using threat or intimidation or any other means not involving a deadly weapon, and that would be a Class 6 felony. So what you see before you, as far as a number of different areas in the code, the privacy of juvenile records, where, for example, the first 2 categories would be public information, to issues of how you determine the midpoint of sentencing, issues involving barrier crimes. We've made a number of corrections both in the House as well as in this great group that came together to make sure that the B3, which is the one that deals with a deadly weapon where there wasn't serious injury, is properly reflected. And for example, in burglary, since burglary covers a class, covers by this fact of coming into someone's house with a weapon, it is by definition then something that is covered under this particularly stronger language than it might be otherwise described. So again and again, what you see before you, certainly counsel can go through it, I can go through it piece by piece, what has been resolved.
So, Doug, just so I'm clear, what you're mainly focused on is not necessarily the substance of robbery or what constitutes different classes. You're mainly focused on cleaning up how it applies in the sentencing side. Is that right?
It's also in sentencing, as far as the midpoint of sentencing. That also is another section that has been addressed. It also, as far as earning of good time, obviously a significant difference in the classes in how you would earn good time.
So, Senator, Delegate, one of the other things that often arises when we do these things is whether or not the bill is intended to have a retroactive application. And on sentencing, we can have a retroactive application. Have you given any thought to that?
The sentencing issue has been addressed. You'll see in the third enactment clause that was added in the substitute, where it deals with the ability to come in and have your time in prison reviewed based on the circumstances that actually existed in the crime. But no, there is not retroactivity as far as the commission of the crime. As I understand it, I certainly will be corrected by counsel, but I'm fairly sure that has been honored, that you don't go back on sentencing of current, but the law has been in effect since 2021, so there's less of that issue than might otherwise if we were starting fresh.
Okay. All right. Does anybody else have any questions for Delegate Watts? Senator Deeds.
I thought you said that the third enactment clause said the bill was not retroactive. The way I read this, it says it is retroactive.
That as far as someone who is serving time, if they want to have their time reviewed based on the classes of if they can document the actual circumstances of the crime, they could have their sentence reviewed and possibly be eligible for a earlier release date.
Looks like our counsel has a view on that too.
Yes, Mr. Chair, I would just echo what Delegate Watts said. The third enactment clause is related to the changes made in the earned sentence credit section, which is in the substitute 53.1.202.3. If you look at line 565, in the long list of offenses that are not eligible for the enhanced earned sentence credits, the bill changes that so only the two higher degrees of robbery will not be eligible for the enhanced earned sentence credits. So the third enactment clause does say that these changes will apply retroactively to anybody who's currently incarcerated, so anyone who's convicted of the two lower degrees of robbery would have the opportunity to get the enhanced earned sentence credits.
Got it. I remember that debate well. Are there any other questions for Delegate Watts?
I have a question.
Senator Perry.
Mr. Chairman, Delegate Watts, I know you talked about earned sentence credits, and it looks like parole is rolled up in here and a bunch of other things, but on lines 254 through 271, it looks like you're also changing 18290 burglary and what would qualify for entering a dwelling, etc., with intent to commit murder, rape, robbery, or arson, and excluding the fourth class of robbery, and under 18250.3, enticing another into a dwelling, excluding the third and fourth, so that you could entice someone in and rob them with, for instance, some sort of a knife or machete or something like that, as long as it's not a firearm. Is that right?
I hope I am following you correctly. You're on 224?
I'm on line 254.
Thank you. In the case of the 245 and also the same thing in 254 are referencing what you have there. In all of the rest of the code sections, the comparable would be 1 and 2. It was interesting as we went through this repeatedly trying to scrub it, that the word deadly weapon is used 15 times in the code and never defined, as certainly been observed. A deadly weapon is a weapon that you use in a deadly way. My mother had metal knitting needles that could have done a real job on somebody. So that becomes then one of those problems within the code itself in trying to separate out the Class 3 felony issue, or not Class 3 felony, the Class 3 robbery situation from Class 2, where it's a weapon, but the issue is, was it used in a deadly way if you were stabbed but not serious bodily injury, if you were scratched by the weapon? All of these things come into the, I would say, the consideration of the case at hand. Counsel, I think, can give a better answer.
Sorry, Ms. May, you got anything you want to add?
Mr. Chair, nothing really substantive, but just as far as on line 256, 257, yes, it does specify the 2 higher degrees, and then in the following crime for burglary, it includes robbery in violation of the 3 degrees of robbery, so would include a deadly weapon, but that's not a firearm.
Mr. Chair,
Senator Perry.
is there, Mr. Delegate Watts, is there a reason that in 18250.3 you included only 1 and 2, and in 18290 you included sections 1, 2, and 3 of robbery, 18.258?
I'm so sorry, Senator. I am not an attorney, and you're going a little fast for me to find the code sections you're referring to. But again, counsel may be following more clearly.
Doug, I think the question is you excluded subsection 3 from 18.250.3, but you included it in 18.290. She was asking if there's a reason that. The subsection 3 is the one who commits robbery using or displaying a deadly weapon other than a firearm. So I guess that would mainly probably be a knife or something. So trying to get somebody to go into a house by displaying a knife. You've excluded that from 18.250.3, but you've included it in 18.2-90.
I thank you, Mr. Chairman, and Delegate Perry for that clarity. Certainly, we addressed that when it came to burglary.
Did I get that right?
If
I'm just still a senator.
did I say delegate?
You're good.
No, you're from the top. You earn being senator. Some of us just whatever. Senator, that yes, we addressed that when it came to burglary. I understand your concern when it comes to kidnapping as far as entering the house, and if that's the will of the committee, I can see where you could possibly, because of the fact that it goes down into victim to enter such a dwelling house, etc. I leave that to counsel, but I would regard 3 as not being unreasonable to add there.
We agree, Mr. Chairman.
I would move to amend.
Okay, Senator Perry moves. Senator, anybody else second? Senator Deeds seconds that we add subsection 3 on line 257. All those in favor say, any discussion? All those in favor say aye. Aye.
Mr.
Anybody
Chairman.
opposed? Mr. Benjamin.
One other change that I think is consistent with the patron's intent on line 285, after the word robbery, we would suggest inserting the same clause that appears at 176 through 178.
176, 178. So this, where during the commission of robbery, the person caused serious bodily injury or death to the other person, yada, 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 that one? Okay. Okay. Senator Deeds moves. Senator Bagby seconds that we add the language suggested by counsel from lines 176 to 178. We add that at line 285. All those in favor say aye. Aye. Anybody opposed? Anybody awake? All right. Okay. All right. Senator Watts, Doug Watts, why don't we take some testimony, see if there's for and against it, unless there's any more surgery anybody wants to do at 8:34 in the morning.
Can I just ask a question?
Yeah, Senator Perry, go ahead.
Mr. Benjamin, can I just ask why you wanted to add that language in? Does that differ from B1 and B2 from the 18258? The rest of the code sections that are laid out under 192297.1 just reference the code section itself, right? Like mob-related felonies, Article 2, 18238, kidnapping, 18247 at all. Is there any reason whenever you're making the amendment to line 285 to add the language from what is your intent in that?
Mr. Chairman, if I may, the answer is it was unclear to us whether an appellate court would rule that this would have a retroactive or prospective application because we tried not to create ambiguity. We added that clause to ensure that the patron's intent was reflected. What that means, more simply, is for somebody to be convicted on a third strike, the Commonwealth would have to prove that the two prior robberies were of this degree. That creates a problem for the Commonwealth, especially with old cases, and I'm certain they'll speak to that. But that was the patron's intent, and so we wanted to be very clear with the amendment that that's what the application would be.
Great. Got it?
Yep.
Okay. So why don't we take some testimony? MJ, why don't we set it at, let's go 5 and 5. I'm not sure we'll get
If there's anyone online that would like to speak in favor, raise your hand.
Go ahead.
Good morning. I'm Michael Newman, Commonwealth Attorney, City of Danville, here on behalf of VACA. And as Mr. Benjamin pointed out, we do have slight issues, but they've done a great job in reference to cleaning up a lot. As been pointed out by some of the senator's questions, there's other points of the statute we would like to keep including B3 in. Quite candidly, credits, I think B3 should be still there in reference to that. You know, if you stab someone on 3 different times in a reference to committing a robbery, you may not meet the code definition of significant injury, but you're still wounding them. That should still be a violent crime. B3 should still be included in that. If you use a machete or a knife or whatnot. So I think they did a great job in cleaning up most of it. I think some of the code sections, example, the one he just pointed out, 19.2, 297.1, in reference to third strike, that should still include B3. VACA believes. So again, just a slight disagreement with the delegate. On the B4s, we don't have a problem with that at all. Just addressing what Mr. Benjamin indicates, I think that's where we have any issue with the bill. Thank you.
Council, didn't we just put B3 in the third strike? I thought that's one of the amendments we just made, isn't it?
Mr. Chair, we did not add it to the act of violence definition. We added it to line 257, dealing with burglary.
Okay. Oh, that's right. We added that other clause to third strike. I got it. Okay. Good. Mr. Green.
Mr. Chairman, Nathan Green, Commonwealth Attorney for the City of Williamsburg, James City County, here also speaking on behalf of the Virginia Association of Commonwealth Attorneys, speaking to the retroactivity. Prior to 2021, robbery offenses did not have the same elements in them that they do post 2021. So it's not entirely clear to me who bears the burden of showing that the robbery that took place 15 years ago was with a firearm as defined in 308.2, meaning nowadays, if we have a robbery charge, we have to keep the gun, we have to send it to the lab to make sure it meets those requirements. Before 2021, we did not do that. We would have a witness that testified an individual shoved a gun in my face and robbed me. There was no testing of the firearm to make sure that it actually was operable under the definition that has been included in the new offense. Serious bodily injury is a new definition that did not exist before. I believe it came into code about 8 years ago, was added into robbery just in 2021. So the serious bodily injury, we would have the facts on the record could show that there was an injury, but we may not have elicited evidence to meet the serious bodily injury that is now in the code section. So basically, any robbery before 2021 would be a Class 6 felony.
But Mr. Green, but it just incorporates the definition of serious bodily injury from malicious wounding, which has been the law for a million years, right?
Your Honor, Mr. Chairman.
Not yet, no.
Mr. Chairman, It does not.
I hope not.
It includes the serious bodily injury from 18.2 50.4. It's not the same as malicious wounding.
51.4, maiming. Yeah.
No, it's. But if you look at that code section, their definition of serious bodily injury is not the same thing as maiming.
It's been in the code for a long time, though, hasn't it?
But Mr. Chairman, believe I'm correct that the definition as used in the robbery section for serious bodily injury goes to a different code section, not to the maiming code section. It goes to one that talks about permanency and things of that. That is not the same thing as just simply a stabbing or a gunshot wound. You have to show more. And at the time of these pre-2021 robberies, prosecutors weren't putting on the record that additional evidence. And so therefore, the records will be void of some of the definitions that now would be required. And so therefore, pretty much most robberies, if not all, that are pre-2021 will now be Class 6 felonies, and if they've served more than 5 years, they shall be released. That's my read of the retroactivity.
And Mr. You're assuming that I guess the Department of Corrections is going to find that the Commonwealth has the burden to show what degree of robbery it was 10 years ago as opposed to the incarcerated person?
No, I believe the judge will. My understanding is that this would be brought back to the court for a sentencing modification, or I'm not sure who's responsible, but if the records are unclear as to whether someone meets the definition of using a firearm as defined in 308.2 or meeting the definition of serious bodily injury, then my read would be the individual should be treated the same as the lowest level of the offense, which is the Class 6 felony. And, Mr. Chairman, I'm looking at as the definition of serious bodily means bodily injury that involves substantial risk of death, extreme physical pain, protracted and obvious disfigurement, protracted loss or impairment of the function of a bodily member, organ or mental faculty.
Right.
We weren't putting those types of, that we weren't establishing that evidence in a robbery case before 2021 because we didn't have that definition of serious bodily injury.
Okay. Anybody else in favor? Anybody online?
Mr. Chair, there's no one to speak in favor at this
Okay, let's
time.
reset the timer. Anybody opposed to the bill?
If there's anyone online that would like to speak in opposition, raise your hand.
Nope. Okay. Oh, McDougall. You
Mr. Chairman, I just
can close the testimony stuff. Go ahead.
a couple questions, and Mr. Green's presentation scared the heck out of me. When we look at this, who is making this retroactive application? It does not determine that it's state police, Department of Corrections, or court. So on line 653, if it is determined upon retroactive application, who's doing that?
I mean, counsel can answer, but my recollection is with regard to the existing earned sentence credit system, which had retroactivity, the Department of Corrections made that determination. But counsel, is that, I mean, that's who did it last time. I would assume it's going to be the same this time.
Mr. Chair, if we are referencing the retroactive application of earned sentence credits, that would be my understanding that it would be the Department of Corrections.
Is this the same, like, Mr. Chairman?
Yeah, Senator McDougall.
Is this the same language that's used in that statute?
Mr. Chair, with differences just because of the way it applies to robbery, but the rest of the language that deals with like the second half of the enactment clause is the same as the retroactive clause for the original earned sentence credit bill.
So, Mr. Chairman.
Senator McDougall.
So, Department of Corrections, all they're going to have is the presentation from the individual this is being applied to and potentially a record. So no victim, no Commonwealth's attorney, and they'll just look through the list and make a determination. So if it was not placed on the record, then it'll be determined not to meet one of the previous A, B requirements. Isn't that accurate? Mr. Benjamin?
I have an answer. You don't want my answer, I guess.
Because it's probably not right, but that's.
I haven't been right since 1990 in JMU student government, have I?
That is factually accurate.
All right.
See, we can agree.
Mr. Chairman, if I may, as I follow Senator McDougall's reasoning, that's absolutely right. There will be a lot of people whose record will not sustain the actual degree of robbery that they committed, and they'll be sitting there, and they're sitting there today. This just opens the door for some where the record does indicate that the degree of robbery was one of lesser degrees.
But counsel,
Chairman,
am I
I'm not
correct that when the earned sentence credits were applied retroactively, the Department of Corrections created a system and a process in consultation with the Attorney General's office. And the Attorney General actually scoped back the earned sentence credits and actually we have another bill later in this docket to undo one of the Attorney General's opinions. And so, my recollection is that DOC will create some kind of a system. This doesn't fully flesh it out, but do you think
In addition, Mr. Chairman, a number of these convictions will include such things as pre-sentence reports, which will describe the offense, and sentencing guidelines, which also have a data field indicating whether or not a firearm was used, for example. So I think that the record will not be nearly as unclear as has been suggested.
Senator McDougall?
Mr. Chairman, but it would not include, under this definition, if there was not a firearm, if there was a knife used and somebody was cut, but that cut did not result in them loss of use of their limb or digits or internal organs, then they would fall under this category and be released.
There's no categorical answer that can be given because a lot of these cases will also include victim impact letters, victim impact testimony. I suspect that there will be a wealth
Mr.
of
Chairman,
evidence that can be drawn upon.
That also is a great answer, but on A, it has to do one of two things: cause serious bodily injury under the new definition.
It's not new.
Under the definition that's not maiming that we traditionally used in that assault section, or they have to use a firearm. So anything else gets released.
It's the definition of maiming.
Not the aggravated assault.
Not malicious.
Malicious wounding.
Yeah, it's maiming.
So you can be injured, could be cut by a knife, but if that's not determined to be life-threatening or a permanency injury, then you'd be released.
Doesn't create a risk of death, extreme physical pain, projected and obvious disfigurement, or protracted loss of impairment of the function of a bodily member, organ, or mental faculty. So,
yes.
Okay, we've debated this one pretty good, I think. Anybody else have any other thoughts or comments? Nope. Okay, let me see. Where's this one going? Is this one going to finance? Really? It's got to go to finance. Oh, no, it doesn't go to finance. Wow. Okay, Senator Boysko. Okay, it's been moved and seconded by Boysko and Senator Carol Foy that we report the bill. Any further discussion? Clerk will open the roll.
Ayes 9, noes 5.
Thank you, Delegate Watts.
Thank
Nothing
you,
like
Mr.
a
Chairman. Thank you, Senator Perry.
big meaty one first on the docket. Wow. Okay. Delegate Cherry. You got something easier for us?
I certainly hope so, Mr. Chairman.
Okay, we got 633, right?
633, yes, sir.
And you have a
we
sub?
heard a lot of testimony on this on Wednesday. Yes, sir, I have an amendment in the nature of a substitute.
Yeah, and just so that everybody's aware, we already heard a lot about this. Oh, God, this is another big one. Great. All right, Senator Deeds moves. Boysko seconds the substitute. All those in favor say aye. Aye. Anybody opposed? No. Okay, subs before us. And, wow, a lot fewer words this time, huh?
Yes, sir. A lot fewer words. That's
Good.
what you said you wanted. That's what I brought you.
Yeah, good. That makes it easier. Okay. Okay, why don't you explain to us what you've done?
Mr. Chairman, I'd be happy to, or I could have Mr. Benjamin, who helped us draft this with extensive work over the weekend. If it's okay with you, I'll have him present it since these are his words.
All right, Mr. Benjamin, tell us how we have not taken this federal statute with all this reasonable person stuff and narrowed it down to something that's much more Virginia.
Mr. Chairman, under current law, that's 18.2-47. That's an abduction statute. It looks like in 2009, the General Assembly amended the abduction section by inserting subsection B, which criminalizes a tremendous amount of the conduct that was in the original bill that was presented to the committee. And so, seeing that, what we did was to, in the substitute, use the existing statute, 18.2-47, which begins on line 22. And then on line 28, we moved from the bill that was originally presented to the committee those categories of conduct that were missing from subsection B. So, for example, we added the clause obtains the labor or services of another person. We added the threat to seize or take or detain. And we added to the definition of intimidation to include conduct that had been specifically described to the committee by Aaron Barr of threatening to separate another from a family member. Those would be the amendments to subsection B. You'll also see in the original bill a criminal penalty. It was the act of obtaining money or financial benefit or pecuniary benefit from this kind of conduct was in the original bill. We already had that in existing language in 18.2-356, receiving money for procuring a person, little Romanet 2, double I, causing any person to engage in forced labor or services. That had been squeezed in with prostitution, and so we struck it from little 2 and created a new little 3 so that any person who receives money or any valuable thing for causing any person to engage in forced labor or services or providing or obtaining labor or services by any act in violation of, now we cross-reference to subsection B of 18.2-47. In short, we took existing statutes and fine-tuned those statutes to ensure that we were criminalizing the additional types of conduct that was described to the committee the other day.
Okay, this seems to make a lot more sense. Are there any questions for Mr. Benjamin or Delegate Cherry? No other questions. We already took testimony, so we're not going to take support and opposition. Senator Deeds moves, Boyska seconds, bill be reported and referred to Finance. Clerk will open the roll.
Ayes 14, no zero.
Great. Thank you, Delegate Cherry, and thank you, Mr. Benjamin, for your good work on that, and to the UVA law students I know who put a lot of time in on that as well. Next up, I have Delegate Helmer. And I got Helmer, Srinivasan, Kent, Martinez, Simons, and Sullivan. Helmer, you have 2, I think, right?
No, Mr. Chair, just
just one?
We already took care of my my cognate.
Oh, got it. Okay, just one. So we have House Bill 466. This has to do with reciprocity on concealed handgun permits, and there's a line amendment that I'd like to propose that Delegate Helmer's worked on a little bit as well since I proposed it. So you want to explain the bill, then we'll do the line amendment?
Thank you, Mr. Chair. Mr. Chair, this bill simply says that Virginia law will govern the issue of Virginia concealed carry permits, that you can't go concealed carry permit shopping out of states on a bipartisan basis. We have about 22 reasons in the Commonwealth of Virginia that we would not issue a concealed carry permit, and this just simply ensures that as we recognize concealed carry permits from other states, that they meet Virginia's standards. The proposed amendment simply puts a time frame on this and requires the Attorney General to indicate where he sees other states being in alignment with Virginia law.
Counsel, can you circulate the proposed amendment, the enactment clause we circulated?
Yes, Mr. Chair. The first part has been circulated, but there's one additional change that I'll need to orally report. So the amendment that's been circulated adds an enactment clause that says that state police, in consultation with the Office of the Attorney General, will review any current agreements for reciprocity that are in place as of the time this bill will go into effect, July 1st, 2024, to determine whether the requirements and qualifications of that state's laws are adequate to prevent someone from getting a concealed handgun permit in the Commonwealth. And they would need to revoke any reciprocity agreement for any states that don't meet those qualifications by December 1st, 2024. And there will be an additional amendment that says, added on to this enactment clause, that says the Attorney General shall provide a written explanation for all determinations that a state's laws are adequate to prevent possession of a permit or license by persons who would be denied a permit in the Commonwealth.
Okay, so everybody understand the amendment? Okay, Senator Deeds moves. Boyce seconds the amendment. All those in favor say aye. Aye. Anybody opposed? Okay. Any questions for Delegate Homer? This bill basically takes us back to the law pre-what, 2014, 2015, something like that. Yeah, okay. So why don't we set it at 3 and 3? And why don't we do anybody in support? Come on up.
If there's anyone online that would like to speak in favor, raise your hand.
Chairman, Andrew Goddard, Virginia Center for Public Safety. We've heard testimony that the Virginians with a concealed handgun permit are the most law-abiding. What we don't know is whether people from other states have met that same standard. So we shouldn't ask Virginians to put up with someone coming from another state who would not be able to get a permit in Virginia getting away with carrying concealed without having gone to the same standards. Thank you.
Come on up.
Good morning, Mr. Chairman, members of the committee. My name is Lori Haas. We certainly support the bill. We know that, as the delegate has explained, there are prohibitions on persons who are residents in Virginia getting these permits. We also need those prohibitions to apply to anybody who happens to live in another state in the country, and we hope you'll pass the bill. Thank you.
Mr. Chair, we have one person online that would like to speak.
Okay.
Kendall Jacobson, you can unmute and please make sure your camera's on.
Thank you, Mr. Chairman. Kendall Jacobson with Everytown for Gun Safety and Moms Demand Action. For all the reasons previously given, we support this bill.
Great. Thanks for being quick. Okay, anybody else? That's it? Okay, let's reset the timer. Come on up.
If there's anyone online that would like to speak in opposition, raise your hand.
Mr. Van Cleve.
Mr. Chair, Philip Van Cleve, VCDL. Actually, the record nationwide is excellent. No states are having problems with their permit holders. This bill would also affect negatively Virginia permit holders because now this would mean a bunch of states would no longer honor our permits when we travel. So there is nothing to be gained by this bill and plenty to be lost. We stand strongly against it. Thank you.
Mr. Van Cleve, that's a quick question. You would agree, though, that Virginia has about 22 restrictions on concealed handgun permits, which, for example, Texas doesn't have. So in Texas, you basically can't be a felon and you got to be a citizen or something. That's about it, right? And so if you couldn't get a permit in Virginia because, say, you were found mentally incompetent, you could go down to Texas and get a permit in Texas, and then you could conceal carry in Virginia if you're a Virginia resident.
But this doesn't,
right now, today, right?
Yeah, this doesn't. This is it, you're saying this bill. There's a change in here that says you can't do that.
Yeah.
But I thought this was saying if you're from Texas, you can't carry in Virginia with a Texas permit.
All right.
You know, if that's the case, they're
that too,
every bit as law-abiding down there as they are here with permits.
Okay. NRA. In person today.
Taylor McKee, National Rifle Association. We oppose the bill. I'd argue that concealed handgun permit holders are the least likely people to commit crimes and the most responsible gun owners. This is just another attempt to attack individuals who exercise their constitutional rights, and this will jeopardize Virginians' ability to legally carry in other states because it'll put the reciprocity agreements in question. Thank you, Mr. Chairman.
Thank you. One more.
Good morning, Mr. Chairman, members of the committee, Patricia Webb. I won't repeat all of the things that have been said before, but I will point out that federal law prohibits someone that is mentally incompetent or the vast majority of our prohibiting factors from even possessing a firearm. So those people legally can't possess and therefore can't concealed carry a firearm legally anyway. So to answer your question, that's not an issue. Thank you for your time.
Great. Anybody online?
Mr. Chair, there's no one to speak in opposition at this time.
Okay. Anything else you want to say, Doug and Hunter?
Thank you, Mr. Chair.
Looks like Peek has a question for you.
I'm sorry?
Peek has a question for you.
Question
absolutely.
for the patron, Mr. Chair. Thank you.
Go ahead.
Do you have any statistics or any information that we've got out-of-state concealed carry permit holders who are committing crimes in Virginia?
Thank you, Mr. Chair. Mr. Chair, I'd answer the senator that one of the challenges we have is that the Virginia State Police today do not gather statistics on crimes committed by those who have concealed carry permits. Is not a piece of data that we actually gather. So we can't know that. What we can know is that you can go, one of the things that this bill would change on line 45 is it doesn't allow somebody who would be allowed to have a concealed carry permit in another state but be prohibited from Virginia from, as the chair said earlier, go out of state, obtain that concealed carry permit, and come back into Virginia even though they wouldn't be otherwise qualified.
Any other questions? Nope. Okay. Anything else you want to say? All right. So Bill's before us needs to go to finance if you report it. Senator, okay, Perry moves and Senator Salim seconds. The bill be reported and referred to finance. Clerk will open the roll.
Ayes 9, noes 5.
Thank you, Mr. Chair.
Thank you, Delegate. Delegate Srinivasan, you have 2. Let's do 916 first and 1515 second.
So thank you. Good morning.
916
Thank you,
is a
Mr.
substantial
Chairman.
risk order reporting system. Why don't you explain to us what it does?
Thank you, Mr. Chairman and members of the committee. HB 1515 seeks to require.
Well, I was on 916 first. I'm sorry. You want to? I was going to do 916 first.
Oh, 916. I'm sorry.
Yeah.
Sorry. Thank you, Mr. Chairman and members of the committee. HB 916 is a simple transparency bill that seeks to direct the Department of State Police to publish information on substantial risk orders contained within the existing Virginia Criminal Information Network on a monthly basis. The published report would remove personal identifiable information, leaving sex, race, and the number, and it will just publish the number of SROs issued by the jurisdiction available.
Right. So this basically means that you'd have something up online showing substantial risk orders issued by jurisdiction, so I wouldn't have to send an email to the state police to get the data every year. Okay. Any other questions for Delegate Srinivasan about this?
Yep.
Is there anybody opposed to the bill?
If there's anyone online that would like to speak in opposition, raise your hand.
Doesn't look like it.
Refer to finance.
Let's see, does it need to go? Yeah, it's go to finance. So Deeds moves, Boyska seconds, report and refer to finance. Clerk will open the roll.
Ayes 9, noes 5.
Great. Delegate, next you have electronic discovery. You want Commonwealth attorneys to have to provide discovery.
Yes, sir.
Electronically. It's starting July 1 of 2026, like the rest of the world.
Yes. Thank you, Mr. Chairman and members of the committee. HB 1515 seeks to require that discovery materials be sent through electronic means unless it's impossible to do so or prohibited by statutory law. This would apply to the Commonwealth attorneys who are not required by law to provide discovery materials by electronic means now. This places a big burden on the counsels of record and their clients.
1515. So basically, Delegate, you're making it so that if counsel wants to get discovery in a case, they don't have to go and drive to the Commonwealth Attorney's office and sit down in the office and look at paper and then ask for a bunch of copies and do all that. It's just given to them digitally, right?
Yep.
Okay.
And in some cases, they have to write it by hand.
Okay. Looks like Senator Perry has a question.
I have a question. Mr. Chairman, Delegate Srinivasan, good morning.
Thank you.
My question is about the word electronically. Whenever I was a prosecutor, first of all, let me say this, to be clear. I love to have it documented, every single piece of evidence that I turned over, because then I could prove that I had turned it over, right? So I think there's something to that. I've scanned 1 billion pages and emailed them, chunk by chunk by chunk to make sure that I had that. Mm-hmm. My question is about, though, wouldn't it be uncommon in a case where the law enforcement would come and drop off some massive hard drive, right? That's like a terabyte hard drive. for me. And what I would do is I would have my legal secretary copy that hard drive onto another hard drive, and then I would give counsel the hard drive. They would come by the office and pick it up, and we had mirroring hard drives. I guess my question for you is, do you consider that electronically providing, or am I now required to download that terabyte of information onto a computer and email it to counsel?
Yeah. In that situation, Mr. Chairman and Senator Perry, in that situation, providing the information in a floppy or in a terabyte disk, in a floppy, would still be better than what is being
This ain't
done
like
today.
1985, man. Come on.
Well, today they're making hand copies. So even if you provide it in a floppy, it's fine. If you download it, it's fine. Because right now, there is no electronic means. There may not be any electronic means. It depends on office by office. So what I've heard is there are many councils who have to go over to the other side and handwrite information. They can't even make copies. They can't even make a photo.
Senator Perry.
Yeah, I understand that part of the bill. No one has to come in and copy, handwrite information. I understand that, and they don't even have to come copy their own reports. I'm not opposed to any of that. My concern is just it's not uncommon where we'll have cell phone dumps, right? I've had cases with 15 cell phone dumps, right? Those are usually on a thumb drive or a hard drive. And the way I read this bill, I don't know that that's electronically providing it to them. And maybe I'm wrong about that. Maybe someone has a different definition of electronically provided, but I would be interested in whether that would still be sufficient.
Mr. Chairman,
Maybe
can I
counsel can
ask
answer that question.
If you gave somebody a floppy, that'd be like trolling them almost. I mean, why don't we take some testimony really quick, and maybe the Senator Perry's question will be answered. I think Baca has something to say about this.
Mr. Chairman.
Yeah, Senator McDougall.
So when they're doing that, is a fax considered electronic? So a lot of prosecutors still use faxes, at least where I practice. And number two, what if a Commonwealth's attorney just has an open file system? Is this now requiring them to actively send everything as opposed to letting somebody come and just look at the file? So is this totally changing how we do discovery in some places?
Mr. Chairman.
Senator Perry.
I have another question. It wouldn't be uncommon also if I had a case, sometimes we will go out and I will provide discovery by going out and looking at the scene. How do I provide that electronically to counsel? The way I would do it typically is I would document in my file that I went out with counsel, whoever was present, this is what we looked at, blah, blah, blah. But I certainly can't provide that electronically to anyone.
Yeah, so Mr. Chairman, if I may.
Delegate, go ahead.
Thank you. Senator Perry, that's why in the bill we have provided, unless it's impossible or prohibited by statutory law. If it's not possible, obviously we can send it electronically. And if it's not, if it is prohibited by statutory law, of course you can't. But given how it is done now, this bill would be an improvement. And that's why we haven't delayed enactment for 2 years, because I got input from stakeholders. And that's why we provided for 2 years of delayed enactment.
Right. So I guess the details get worked out in the rule process. The rules process, I think, is what he's. Yes.
I'm still not sure that solves the terabyte issue, right? The hard drive issue.
Right.
That's.
Okay.
Mr. Chairman, I would think that that would
Mr.
be
Benjamin.
I would think that would be electronic. That's how it gets onto the disk, onto the drive, is electronically.
Yes.
And that's how you retrieve it from the drive, is electronically. And I think any attorney who argued otherwise would be an idiot.
Okay.
I hope that's not a comment about me.
No,
Mr.
of course it
Benjamin.
was not a comment on Senator Perry. It was a fair question. I was referring to others.
Okay. All right. Is there anybody? Why don't we do 3 and 3?
If there's anyone online that would like to speak in favor, raise your hand.
Mr. Chair, Rob Hogan-Class, Justice for Virginia. We strongly support this bill. There are still places in the Commonwealth where people are asked to come and review the Commonwealth's file and can only take handwritten notes from the file. That's simply inefficient. It's insufficient, and it's a difficult way to practice law when you're only able to hand copy from the file. So providing that in electronic means, as other states do, would bring us into the 21st century. We appreciate the delegate for bringing it. Thank you.
Okay. Anybody else in favor? Doesn't look like it. Anybody online?
Mr. Chair, there's no one to speak in favor
All right,
at this time.
Let's reset the clock.
If there's anyone online that would
Anybody
like to
opposed?
speak in opposition, raise your hand.
This is Vaca.
Good morning, Mr. Chairman and members of the committee. I'm Heather Havermel. I'm the Commonwealth Attorney for the City of Winchester here on behalf of VACA. We do oppose this bill for two reasons. One is that the fiscal impact is going to be great. The other is that it is a one-size-fits-all that does not fit for some of our jurisdictions. Now, I will tell you that I do have electronic discovery in my jurisdiction. It is the preference of our police department, but we have one police department that we receive the information from. As far as I know, there is one software company that currently can handle this type of discovery dissemination, and that's Axon. We pay roughly $3,000 per user per year for that. Spoke also with another larger jurisdiction that does the same. So looking at, we have a little over 1,000 Commonwealth attorneys in the Commonwealth. You're looking at approximately $3 million for the software that would be required for this type of undertaking. But that's only in the jurisdictions where it works, such as mine. You're also going to have some jurisdictions that have multiple law enforcement agencies. Some of those agencies will have the ability to provide the discovery to the Commonwealth's attorneys through Axon. Others will not, because they will have other software or no software at all. In those cases, you're going to have somebody who's available to do what Senator Perry indicated, which is scan hundreds and thousands of even more documents into the systems to be able to provide it this way. This simply does not work for some of the small jurisdictions. There are some places where they do prefer to come into the Commonwealth Attorney's office and copy the discovery. In fact, I still have some defense attorneys in my jurisdiction that aren't very happy with the situation. So it's for these reasons that we oppose, and I'm happy to answer any questions that you might have.
Mr. Chairman?
Senator Carol Foy.
Question.
Go for it.
Okay. So in the bill, I believe it does have a provision on line 13 and 14 that says, or carves out, that you have to do this unless it's impossible to provide by electronic means. Is that correct?
Yes, Senator, that's my understanding. But
Okay.
of course, you'd
and
have
then
to.
also a follow-up question.
Go ahead, Carol Foy.
Also, if you have attorneys in your jurisdiction who want to handwrite or copy, once you send it electronically and they want to go then and handwrite and copy, I mean, they have the option. I mean, the goal is for them to get it, and they would get it by electronic means. Isn't that correct?
Well, Senator, I would disagree with that because we do have obligations, other obligations, and if you're taking the time to have us do both electronic discovery and to meet with people in person, that's going to be unduly prohibitive.
A
Senator
follow-up
Carol
question,
Foy,
Mr.
go
Chairman.
ahead.
I apologize, that wasn't my question, that you have to follow up and meet with them. You stated that there were some attorneys in your jurisdiction who like to come in and to copy, but if you send it to them by electronically, they have it. So even if they then wanted to go and make notes and annotations and handwrite what you've provided them, they can do that, correct?
Some don't have the technological capabilities. There are some that simply aren't operating in the time that we are in.
I understand. Last follow-up, Mr.
Go ahead.
Chairman.
Go ahead, Senator Carol Foy.
And this does have a 2-year reenactment clause, so they have 2 years in order to figure out how to get the technology, to gain the financial resources, whatever they need to do. So this provision doesn't even come into play until 2 years from now. Is that correct?
That is my understanding, Senator.
Thank you.
Mr. Chairman.
Senator Perry.
Mr. Chairman, good morning. My question is, we had Axon in Loudoun, so I'm familiar with it, and we really struggled to get Leesburg and the sheriff's office, our two biggest providers on there. I think the other people still are not on there. Town of Middleburg, Percival, all that other kind of stuff. But what we did for many years, and I think this goes back to my earlier point that I was trying to make, is like body cam and stuff like that came off of law enforcement. They would copy it onto CDs and things like that, and then the sheriff, whichever Percival or whoever would make a copy of it. Leesburg, before they had Axon, right? Make a copy of the disc. They would keep a copy. They would give us a copy. If we were really lucky, they would bring us a copy and defense counsel a copy, right? And then we would provide that, quote unquote, electronically per Mr. Benjamin, to council. So I guess my question is, it doesn't have to go through Axon, and I agree with you. Axon is incredibly expensive. It's probably cost prohibitive to a lot of jurisdictions. It took Loudoun a long time, and we're a pretty wealthy jurisdiction. But my question is just, I think there are other ways to get around. I don't think it has to go through Axon.
I wouldn't disagree with you, Senator. However, I would say that you had to be very careful, and I'm sure as you're aware as a prior prosecutor, you have to be very careful because when you're dealing with discovery in electronic means, you do not want to risk someone not getting their discovery. So you have to have a way that you can track how the discovery is being disseminated, and I do believe that Axon is currently the best way to do that.
Mr. Chairman.
Senator Perry.
To be fair, I don't think that is responsive to my question. I've provided discovery 1 billion times in my life on discs and things like that, right? I have copies. I look at both of them. I make sure they contain the same material, and then I go through and I itemize each and every item on that disc, and I send an email to council saying, here's what I have provided you.
Right.
Here's everything I have provided you. If you do not have what I have, please let me know. And I think that's pretty close-ended, and I think you can do it that way. I don't think you have to have Axon.
Right, I mean, can't you just send somebody an email with a PDF attached? Says, here's my file. I mean, you don't have to send it through some like $3,000 per user system, right?
Well, respectfully, Senator, we don't have PDFs of all of the discovery now. A good bit of our discovery is now large files. We're not just talking documents. We're also talking body-worn camera, video surveillance, phone dumps, as the Senator indicated. So it's just not that simple anymore.
Right.
Mr. Chairman,
not in every case, Mr. Benjamin, yeah.
What might help for these other situations is if you inserted the words upon request. So if you have jurisdictions or attorneys who are not comfortable with electronic discovery, they could then still go into the office and make copies. But if anyone wanting electronic copies could then request.
Yeah, well, I guess somebody wants to sit there with their dictaphone and look at papers.
That's right.
So,
That would remove the mandatory provision.
I don't think this is that big of a deal, but why don't we finish up the testimony here? We got 1 minute and 10 seconds left, and we need to move this docket along. So,
thank you.
Thank you. Is there anybody else who's opposed? Nobody else opposed? Nobody online? Okay. Back to the podium, delegate. Okay.
Thank you.
Any other
Thank
questions?
you, Mr. Chairman.
Huh?
I said thank you, Mr. Chairman. I was
Okay.
going to say Microsoft SharePoint is an electronic means.
Got it. This one needs to go to finance. So Carol, I think it was Carol Floyd, right? Carol Floyd moves, Perry seconds the bill. Got it. Everybody on there moves and says go to finance. Okay.
No, we didn't do it.
We didn't do an amendment. Clerk will open the roll.
Ayes 10, noes 4.
Thank you. Thank you, Mr. Chairman.
All right. Thank you, Delegate. Next up, we have Kent, Martinez, Simons, Sullivan, and Arnold. Delegate Kent, you're going to talk to us about jet skis.
Yes, sir.
I think everybody's pretty familiar with the bill.
Okay, great.
I think. We've all seen video and stuff, but you could give us like a 60-second explanation that'd be helpful, I think.
Okay, yes, sir. I'll give you the abridged version. I'm glad you've seen the video. I was going to preface this with kind of remarks regarding the video. This bill has been the work of multiple stakeholders. It's bipartisan effort to protect commercial watermen due to the unique dangers that they face just to provide for their families and their livelihood. Our bill shows, the video regarding the bill shows them at work in their wetsuits with anchors and dangerous equipment trying to do their job when they were approached by a jet ski which impeded them from doing their work. There's nothing currently in this section that addresses this. So this bill creates code section, Section A would define commercial fishing. Section A. Section B then states that if you willfully and intentionally impede a commercial fisherman, you be found guilty of a Class 1 misdemeanor. We use this section specifically because it would allow for restitution. A lot of times, these are not salaried folks. They are folks that whatever they're catching is what they're making that day. The jet skiers were folks from the local Union 400 that needed that for their livelihood.
So, Delegate,
Yes,
does
sir.
anybody besides Senator D. Staff and the Jet Ski Caucus oppose this?
No, I have not spoken to Senator D. Staff, but I have lots of folks here that would love to speak regarding it. Even some folks that were on the boat.
I
not
don't
the
think
jet
you
ski.
need to snatch deep in the jaws of victory here. Is there anybody who's opposed to this bill?
No, sir, no one's opposed.
One opposition. Come on up.
Okay.
If there's anyone online that would
We
like
have
to
a jet
speak in
skier here.
opposition, raise your hand.
I don't know, 2 and 2.
Good morning. My name is Andy Cortez from Mechanicsville, constituent of Senator McDougal. I'm not opposed to the sentencing on this. It makes sense for it to be a Class 1 misdemeanor, and it's a dangerous job that they have. And I think it should be enforced equally, though. We already have 2 laws that have been on the books for 27 years that address impeding fishing. The Constitution allows lawful fishing, and those laws ensure that people can go fishing. The law applies equally to commercial fishermen and recreational fishermen. The new law, which will go in, I think it's section 18.2, that will only address commercial fishermen. Now, back when the legislature passed the law, boy, I wish I had more time to talk to you. I'm not going to have enough time, but I tell you what, here's my concern. I think what we need to do is to take a look at Section D of this section. It puts unfair burden on commercial or recreational fishermen, hunters, and trappers. There's no evidence that they were on that jet ski. That jet ski was an anomaly. In 27 years, that's the only case VMRC's made and prosecuted. 27 years. That means the current laws are working. It's a deterrent. People are voluntarily doing the right thing. And I'll tell you something else. We've got 590 licensed fishermen, 590,000 licensed fishermen in Virginia. They're not out there just to mess with commercial fishermen. Thank you.
Great, and thank you for that. And I think if there's a concern about recreational fishermen being interfered with, I think that could be a subject of a different bill as opposed to this one. But appreciate your concern, Senator McDougal. You have something,
Mr. Chairman? Maybe this is for Delegate Kent. Section D. Then, if you're convicted, you're prohibited from using like seine nets and the like. What's the logic between that and the rest of the bill?
Section D is the boating course. I'm sorry.
So, Mr. Chairman,
Mr.
says
Chair.
first offense is ineligible under 282300.
Oh, yes, sir. So for 1 year, your license would be revoked under this section, which is your boating and hunting license. At a subsequent offense, it would be revoked for 3 years. We amended that in courts committee on the other side, just to state that you would lose your boating license.
Mr. Chairman.
Senator McDougal.
What does hunting have to do with whether you're using a boat? I think that's probably a legitimate question when we're looking at the penalty. I mean, you do one bad thing, there's a punishment that's commensurate. Why would you also lose your hunting license?
I think the intent was to reference that you would lose your boating license. They're combined in this section of code under subsection D. So we were just using that code section to say, similar to driving, that if you are found guilty of this, then you would lose your boating and hunting license under both of these. I'm certainly amenable if we want to make this regarding boating specifically. But
Mr. Chairman, I'd feel more comfortable.
Senator McDougal, go ahead.
I'd feel more comfortable with that. So, Mr. Benjamin, can you help us with?
And Mr.
We
Chair,
need to strike out. We need to strike out. Is it 29.1300? Is that it?
So 29.1-300, that whole chapter does deal with hunting and fishing licenses, hunting, trapping, and fishing licenses. So I don't know if we could just say fishing license under Chapter 3, or if you would like to strike the reference to that chapter altogether.
Yeah,
Mr.
Senator
Chairman,
McDougal.
I was thinking just boating. Should you not be able to fish in a pond if you do this? I don't know that that's the objective.
Senator Bagby does not
Thank you,
like
Senator
people
Bagby.
fishing in ponds. It looks like Chapter 7 is boating, which is 29.1700, which isn't even picked up by this, I don't think, is it? Right now. Am I not reading the chapters correctly? No, it's boat registration identification. Okay, maybe we could do an amendment. You want to take it, go aside really quick, and while we move on and narrow this down, we keep the docket moving. Why don't we do that? Okay, so Doug, you can't go over with McDougal and his lawyer, and we'll bring you back in a second, okay?
Okay, thank you. I do have folks to speak on behalf at whenever the committee would like.
I don't think they need to speak unless they want to
Okay.
jeopardize the bill.
We don't want to do that. No, sir.
Okay.
No, sir.
Okay, next up, I have Martinez. Let's see, Martinez, you've got 243 jerk complaint forms. Doug, did we see this bill last year? Or am I imagining things? No, I know he wasn't, but the bill might have been.
Mr. Chair.
Delegate Krizek had something like this last year, I thought.
Mr. Chair, it was in, I believe, 2022. Delegate Krizek's bill added the subsection B in 17.1917. So that was HB 761 in 2022.
Okay,
And
so
that was
basically,
just the online.
so basically all this bill does is you want to make a standardized form available at every clerk's office in the state for jerk complaints, right?
Yes, sir.
Is there anybody opposed to this bill?
If there's anyone online that would like to speak in opposition, raise your hand.
Nobody opposed? Okay. Okay, there's a bunch of motions down there that we report this. Delegate Martinez is so persuasive without saying a word. He just glares at us and things happen. So clerk will open the roll.
Senator McDougal, how do you vote?
Are you a no, Mark? Yes. Okay. All right.
Ayes 13, noes 1.
Senator Obenshain wants me to explain this on the floor. Okay. All right. Thank you, Doug Martinez.
Thank you, Mr. Chairman and the committee.
Next up,
You're
I have...
fast becoming my favorite committee, by the way.
Next year won't be so lucky. All right. Delegate Simons. You've got human trafficking response teams, 581.
Thank you, Mr. Chair. HB 581 requires attorneys for the Commonwealth to establish a multidisciplinary human trafficking response team. I do have an amendment that was recommended.
A line or a substitute?
It's just a line amendment.
Okay, is that in our packet?
Mr. Chair, it has been passed out, and it would just specify that the Attorney for the Commonwealth needs to invite a representative from the VIDC only in jurisdictions served by a public defender office.
Say that again, Taylor. Oh, I see it right here.
It would just specify...
Jurisdictions that have a PD.
Right, exactly.
Okay, so this law would only apply in jurisdictions that have a PD.
Mr. Chair, that is not correct. The long list of people that in the bill that it says the CA needs to invite to this multidisciplinary response team, in the introduced bill, it had a representative from the Virginia Indigent Defense Commission, now only a representative from VIDC, where public defender offices will need to be invited to the response team.
Okay, thank you. All right. So Senator Deeds moves, Boyce goes seconds the amendment. All those in favor say aye. Aye. Anybody opposed? No. Okay, the bill's amended. Doug, explain to us why we need these response teams.
So the goal of the bill is to bring together stakeholders in criminal justice, law enforcement, victims advocates, survivors, labor, school divisions, healthcare providers to coordinate a multidisciplinary response to human trafficking, which is a multi-billion-dollar criminal industry that denies freedom to over 20 million people worldwide. And coming from Newport News, we're especially concerned about this with our major ports, bases, highways, tourist areas. Virginia really can be a prime target for traffickers.
All right, are there any questions for Delegate Simons? Oh, wait, we got to wait. We got to make sure nobody's opposed. Vaca, anybody opposed to creating a response team?
If there's anyone online that would like to
No.
speak in opposition, raise
Looks
your
like
hand.
Vaca's good. Okay. Doesn't look like anybody's opposed. All right. A bunch of people made a motion down there in second that we move this on. Simon, does this have to go to, does not need to go to finance. So clerk will open the roll.
Ayes 14, no zero.
Bill reports.
Thank you.
Thank you, Delegate. All right. Next up, we have Sullivan for red flag order training programs.
Morning, Mr. Chairman.
This bill has to go to finance if it reports.
Morning, Mr. Chairman, members of the committee. HB 637 relates to a risk order training program. Virginia adopted its risk order law in 2020, and it is working. Hundreds of risk orders have been entered around the state. We don't always know the details, but sometimes the press does cover them, and they report sometimes harrowing stories, like in December of 2022 when a judge entered a risk order when a man in Front Royal threatened a copycat shooting after he got a poor performance review where he worked at the local Walmart, and this was just 2 days after the Chesapeake Walmart shooting. There was a time in April 2022 when the Warren County Commonwealth's attorney asked the court to enter a risk order against a man who posted videos of himself online holding an AR-style rifle and directly and specifically threatened the Strasburg Police Department, saying he would come to Strasburg to take back what was his, and the police couldn't stop him, and he would take them all on. And he also included a video of a man shooting another man in the head at point-blank range. The court allowed the police to confiscate his concealed handgun permit, his AR, and his Kel-Tec PF 9mm pistol with a laser sighting. There was another episode of a man who in August of 22 made threats to kill local government officials and police officers in Roanoke, calling the CA's office in a crisis line, saying he was prepared to start killing people. It's time to start ending people's lives, he said. So, Mr. Chairman and members of the committee, people in Virginia are using the red flag law, but they're not using it enough. And what we don't want to do is wake up to a tragedy, wake up the day after a tragedy like a suicide or a mass shooting, to a second heartbreak of learning that someone knew.
So, Delegate, you just talked about Roanoke. I remember the chart I had showed that in Roanoke, they're barely doing these at all. I think one in Roanoke County, one in Roanoke City in the last 3 years. So this is basically an effort to try to train localities to try and use them more, right?
It is. I look at the same charts you do. Yep.
There's also a bunch of federal money that's available that we haven't tapped that could fund all this, and it's in the House budget as well, right?
It is in the House budget.
Okay. All right. Anybody have any questions for Delegate Sullivan on how we can use federal money that was passed on a bipartisan basis at the federal level to help promote red flag orders in our state? Is there anybody opposed to the bill?
If there's anyone online that would like to speak in opposition, raise your hand.
Okay, we got some opponents. Why don't we set it for 3 minutes, MJ?
Mr. Chairman, Philip Van Cleve, we oppose red flag laws all the way around. The substantial risk is being unconstitutional. So training people to violate the Constitution and somebody's rights, we're not in favor of that. Thank you.
Mr. Chairman, Patricia Webb, VCDL. As Mr. Van Cleve said, we oppose violating the Constitution in any way, shape, or form. The other thing about this bill is it doesn't focus on getting people in crisis assistance. They're still left out on the street, unsupervised, untreated. I suggest to this committee and the entire body that it would be much more beneficial and effective to look at our mental health facilities and opportunities to get people the help that they desperately need. Thank you for your time.
Thanks. NRA.
Yes, sir.
You guys opposed this training, huh?
Opposed to the red flag orders more than anything, and the due process concerns associated with them. For those reasons, we're opposed. Thank you, sir.
Okay. Anybody online?
Mr. Chair, there's no one to speak in opposition at this time.
Okay. Do we need to take supporters? Just come on up and say who you are and who you're with and you support. I don't think we need to take a lot of testimony.
Yes, sir. Mr. Chairman, members of the committee, Lori Haas, we certainly support the bill. There are far too many circumstances where law enforcement, public safety officials, especially officers on the ground, don't understand the circumstances under which they can, in fact, apply for and get a risk order. We know of a case where a woman was threatened by her boyfriend. The text was, "I'm going to get a gun and shoot her." That jurisdiction got a risk order. I know personally of a case where a woman called and said, I'm in a relationship that is going south. I need to get a risk order. And the law enforcement officer said, I don't know what you're talking about. I can't help you. We need this training. We need this bill. Thank you.
Mr. Chairman, Andrew Gorham, Virginia Centre for Public Safety. We support the bill. I see this as a perfect complement to your bill, Senate Bill 258, which makes clarifications on use of this risk order. And I think this would be a great way to promulgate those new restrictions or new guidelines that you've put in your bill. Thank you.
Thanks. NAACP?
Virginia NAACP, we support.
Great, thank you.
Mr. Chair, we have 2 people online that would like to speak.
All right, online people, you got 1 minute, 37 seconds.
Katie Fox, you may unmute.
My name is Katie Fox, and I'm from Jose. I volunteer with multiple gun-owned prevention organizations and have done red flag education across the entire Commonwealth. As a survivor of gun suicide loss and my own suicidal ideation, as well as a gun owner myself, this bill is of particular interest to me. I've traveled across the Commonwealth for the last 3 years, stopping in 28 locations, educating the public about substantial risk order, suicide prevention, and secure firearm storage, and spoke with law enforcement stakeholders about their enforcement hurdles. Our substantial risk orders save lives, especially veteran lives, and the only way they can do that is if our law enforcement feels empowered to use them. Thank you.
Kendall Jacobson, you may unmute.
Thank you, Mr. Chair and members of the committee. Kendall Jacobson with Everytown for Gun Safety and Moms Demand Action. We strongly support the underlying law of substantial risk orders, and we've also seen other states that take similar measures to increase implementation of these laws, see a decrease in firearm suicide rates. So extremely important. We support the bill. Thank you.
Thank you, that's it. Okay, let's close the test. Any further questions for Delegate Sullivan?
I move to report and re-refer to finance.
Okay, Deeds moves, Boyce goes seconds, report and re-refer the bill to finance. Clerk will open the roll.
Ayes 9, no 6.
Okay, thanks, Delegate.
Thank you, Mr. Chair.
All right, folks, I've got 2 people telling me they got to be in committee by 10. How many House patrons out there got to be out here by 10 besides Clark and Seibold? Hope too, and Arnold. All right. All right. Arnold's first on the list. And then I got Seibold, Hope, and Clark. I'm gonna go. That's all that's here, really. Oh, over there we got Fowler. Okay, Arnold, come on up.
Morning, Mr. Chair, members of the committee. This is
background checks for Judge Pro Tempores.
That's it, Mr. Chair.
That doesn't happen already?
It's not in the code, Mr. Chair. I think Miss.
Okay, so this does not need to go to finance. You waited all that time for that?
I sure did.
Yeah. Okay. All right, it's been moved and seconded. We report the bill. Clerk will open the roll.
Ayes 15, no 0.
All right.
Thank you, Mr. Chair, members of the committee.
Next, I got Seibold. Seabold.
It's good. It's all good, Mr. Chair.
And this one is House Bill 45. You're looking to reverse an Attorney General's opinion about earned sentence credits for time served prior to conviction. I believe the Attorney General ruled that if you're sitting in jail pending conviction, that doesn't count towards your earned sentence credit, and you're looking to reverse that, right? Okay, and this needs to go to finance. Is there? Hold on. Wait a minute. Hold on. Have I missed anything, Delegate?
There's a substitute, Mr. Chair.
Oh, there is. Oh. All right.
Sorry.
Deeds moves, substitute. Boyce goes seconds. All those in favor say aye. Aye. Anybody opposed? No. Sub is the very first one on your staple packet. What does the sub do that the House didn't pick up?
It basically clarifies the language to ensure that the law is applied as intended, and it also includes a retroactive clause.
Okay, so we're back to the same retroactive discussion that Senator McDougal had. Oh, no, actually, that's a little easier to determine whether somebody was sitting in jail or not, as opposed to the circumstances of a crime. So.
Yeah, it's not.
Yeah. Senator McDougall.
whether you like the policy or not, I don't think they're the same at all, because on the other, you're having to go back for facts that you might not have entered into evidence. This is pretty clear. The question that I would have about the substitute, just looking at it, even though it's on top of the pact, is it doesn't have to be in a correctional facility or detention facility for this charge. So you could have gotten a different charge prior to this and been in a facility, and then that would count.
Counsel, is that how you read it?
Just says, Mr. Chairman, it just says any period of time actually spent. It doesn't limit it to the offense.
Right, except that the first, 10 words say every person is convicted of a felony offense, so I would assume it would be limited to that felony that they were charged with and convicted. That's how the sentence starts. Counsel, do you have a different read of that, or this bill that we almost reported a minute ago?
If it's confusing, we could add the words for such offense.
I'll make that motion. I think
Second. Okay, Deeds moves, Perry seconds. We add for such offense, I guess, on line 18, right before the period? Right? Okay, counsel will figure out where to put it, but I think the idea
I was thinking, actually, on line 15, I'm doing this off the top of my head, but I think any time spent in any spent for such offense in any correctional facility.
Got it. So line 15 before the comma. Okay, it's been moved and seconded. All those in favor say aye. Aye. Anybody opposed? Nobody's opposed. What?
Mr. Chair, you
What?
probably want it down on line 16 after juvenile detention facility, don't you? So it's used to basically include all three facilities, correctional facilities.
Yeah, okay,
state
so it's
hospital,
not, so it doesn't,
juvenile
yeah,
detention
that's a good
facility.
point. Good point, Deeds. Okay. All right. So we're not going to reconsider my motion.
The one question I had, I don't know the answer to this, whether correctional facility only applies to DOC institutions or local and regional jails. I don't know the answer.
Is correctional facility a defined term under 53.1?
Mr. Chair, we'll check. It may be defined, but we could also just add to line up with the language on line 12, state or local correctional facility, if we want to clarify.
Okay, Deeds moves, Perry seconds that we make that amendment. All those in favor say aye. Aye. Anybody opposed? No. Okay. All right, any other surgery we need to make? Okay. And it looks like we have people to talk. All right, why don't we go 2 and 2? All right, come on up.
If there's anyone online to speak in favor, raise your hand.
Come on, Julian Legal, get up. Come on.
And if you are here to speak, if you could move as close to the microphone as possible, I'd appreciate it. Thank you.
Good morning, Mr. Chair, members of the committee. Chuck Mayer representing Julian Legal. We strongly support this bill. It does not expand the existing program. It merely provides a clarification regarding the original legislative intent. It creates no new releases. It's just a simple clarification bill. Thank you for your time.
Thank you, Mr. Chairman and members of the committee. My name is Loretta Reichwein. As someone whose entire family has been personally impacted by the decision not to follow through with the original intent of the earned sentence credit bill, I am in full support of House Bill 45. After an already challenging and emotionally draining judicial process, it was devastating to learn that my brother would not be credited for his time spent pretrial in the detention center demonstrating ideal behavior and growth. My brother has been commended by both fellow residents and staff at the detention center and DOC for his exemplary behavior and positive impact on others. We are not asking for special treatment, merely that he is credited for his rehabilitation and positive behavior that the law passed in 2020 says he earned, regardless of where or when that time was served. To our family, every additional day we get to spend with my brother, in addition to having him at our sister's wedding, our dad's 75th birthday, graduations, and beyond, is momentous to us. This bill would only shorten his sentence by 4 months, which would not impact his overall rehabilitation, but as we all know, time is the most precious resource we have. Thank you.
Thank you. Next up, we got 35 seconds.
Mr. Chair, thank you for this opportunity to address the Senate Courts of Justice Committee. My name is John Lovejoy. 7 years ago, our family encountered the Virginia social justice.
That is other people's time, too.
Yeah, hold on, Deeds, hold on. I got it. Told him 30 seconds.
So let me just read this last statement then. I see 3 key elements embodied in HB 45. self-improvement and self-discipline of the incarcerated, hope on part of family and friends, and mercy offered by our elected officials and administrators. Two of these elements, hope and mercy, provide the bookends to support the inmates' drive for rehabilitation and self-improvement. Without them, incarceration can easily lead to despair. We thank you for considering this with merciful consideration, and we hope this bill clarifies earned sentence credit accounting, and retroactive application. Thank you.
Thank you, sir. I think a lot of us see this as consistent with our original intent, so thanks for your testimony. Come on up. It's who you are, who you're with, you support.
Taj Mayenhef, the Humanization Project. Thank you.
Yeah.
Sean Winetto speaking on behalf of the ACLU of Virginia, and would you support the bill?
Got it. Thank you. Anybody online?
Mr. Chair, there's no one to speak in favor at this time.
Nope. Okay, let's reset the clock.
If there's anyone online that would like to speak in opposition, raise your hand.
Okay. Attorney General does not want us to redo his legal interpretation.
Mr. Chair, you took the words out of my mouth. The Attorney General respectfully opposes the bill. The Attorney General respectfully opposes the bill. Thank you.
Okay. Thank
Mr.
you.
Chair.
I heard a question for Boysko and Perry, I think. Who wants to go first?
I have a question.
Perry, go ahead.
Mr. Chair, can you explain why that is?
The Attorney General, this is an expansion of the Enhanced Earned Sentence Credits Program.
I understand that.
And the Attorney
Yes.
General respectfully opposes any expansion of the Enhanced Earned Sentence Credits Program.
All right.
Mr. Chair.
Senator Perry and then Boysko after that. Go ahead.
Mr. Chair, are you opposed to people getting credit for the time they spent in incarceration?
Mr. Chair, Senator Perry, that's already the law under 53.187.
Thank you.
Okay, Senator Boysko has a question for the AG.
I don't have a question, but I just wanted to make a statement. I was
Okay.
the chief patron of the original earned sentence credit bill, and it was the intention that the interpretation would be consistent with what Delegate Seabold is trying to do here today. We know that when we give people the opportunity to learn and do better, that they will be more successful. And there is data around the country that shows that these are successful and data-driven policies. So thank you for carrying this bill. I appreciate it. Look forward to making a motion to pass the bill.
Okay. I think it sounds like Senator Boysko wanted to report the bill and re-refer it to Finance. 0.4 seconds. And I think this basically is just, there's no real material difference between time sitting in a jail and time sitting in a prison for earned sentence credits materially. And that's basically what you're looking to get rid of. So let's clerk will open the roll.
Ayes 10, noes 5.
Off to Finance.
Thank you, Mr. Chair and members of the committee.
All right, now we got the Hope Parade. Let's see, Hope, you've got 1, 2, 3.
They're all easy. You can move all 5 in a block.
5?
5 in a block. You do the first one numerically, 172?
Sure, okay, 172.
This bill is just changing the definition of family or household member to include legal custodian of a juvenile. This recognizes that we have different situations, different families, maybe kin or taking care of relatives, juveniles, and something may go wrong in the household, and so bringing them into the JDR system affords them different opportunities that they wouldn't get otherwise. They get privacy protection of the JDR court, options for pre-adjudication for diversionary programs, nor family-specific protective orders.
Right. I can't believe this wasn't already the law. So somebody who has legal custody of a juvenile doesn't fit within the definition of a household member.
That's right. So it just recognizes we have changes in how families are represented these days.
Okay. Anybody have any questions? No? Does anybody oppose the bill?
If there's anyone online to speak in opposition, raise your hand.
Nope. Okay, Perry moves, and somebody down there seconds, Salim seconds, report the bill. And sent to Finance. All right, off to Finance. Clerk will open the roll.
Ayes 15, no 0.
Thanks, MJ. Hope.
Next bill, House Bill 786, about restoration of rights for guardianship. 786? 786.
Do we have 786 in the docket? Yes, sir. Oh, it's not on my little sheet here. All right, 786.
786, normally guardianships and conservatorships last until the death of the adult, but sometimes the person's condition improves or their circumstances change and you need to reverse that. But the problem is that a lot of people in this position don't have access to a court. Under current law, they have to petition the court. This just provides that the adult that's not represented by counsel, the adult may initiate the process by informal written communication to the court instead of filing a petition. I've worked with the clerks of the court on this, and don't see any issues. But just allows people, if they want to reverse this, they can do it informally rather than actually going through filing a petition, which they may not have access to.
So counsel, you might make it so that people can reverse a conservatorship informally? Doesn't a JL normally have to be involved in that?
I don't know. Could be.
Okay.
I think he's saying on like restoration.
Oh, okay.
Yeah. That's right.
Just making it.
Okay. Is there anybody opposed to the bill?
If there's anyone online that would like to speak in opposition, raise your hand.
I don't see the clerks.
We had a whole bunch of stakeholders that came together and.
Right. You said you worked with the clerks. Oh, there he is. Hopkins. Clerks are good? Okay.
I like it.
All right. Senator Deeds moves and Boysko seconds, I think, to report the bill. Does not need to go to finance, right, ladies? Okay. Clerk will open the roll. All right. Huh?
Ayes 15, no zero.
Bill reports. Hold on 1 second, Doug. Doug, Kent, do you have a 10 o'clock committee too? Yes, sir, I'm good. Okay, we're going to finish the 10 o'clock committee people first. So, Hope, you've got 797.
This bill is just demonstrating competence when you want to apply for a concealed handgun permit. Requires you to have live fire training for purposes. I have two 15-year-olds that just got their learner's permit. They had to take a test online to drive, and then when they turn 16, they're going to be taking a driving test. So this just says that, look, if you're going to be out there in the real world, you're going to be handling a gun, you should demonstrate competence to do that. That's the first thing the bill does. Second thing it does is it removes references to the National Rifle Association in the code.
Okay, so it basically says that an instructor has to be certified by a state or federal agency and not the NRA.
That's right.
Okay. All right. Is there anybody, why don't we set it to 2 and 2? Is there anybody in support of the bill?
If there's anyone online to speak in favor, raise your hand.
Mr. Chairman, Andrew Garrard, Virginia Center for Public Safety. We support the bill. We believe that people should be able to demonstrate the fact that they can use a gun safely before they're allowed to carry one on the street concealed.
Good morning, Mr. Chairman, members of the committee. My name is Lori Haas. For the reasons stated, we support the bill.
Mr. Chair, we have one person online to speak in favor. Kendall Jacobson, you may unmute.
All right. Mr. Jacobson,
Thank you, Mr.
90 seconds.
Everytown for gun safety, we support the bill. I'll be a lot shorter than 90 seconds.
Thank you. Okay, let's reset the clock. Opponents, come on up.
If there's anyone online to speak in opposition, raise your hand.
We've seen this show before.
Philip Van Cleve, VCDL. This is fixing a problem that we don't have. Those permit holders are doing a fantastic job. They're not causing problems. There's no need to add this unless you want to make it harder to get a permit. We shouldn't be making it harder. It's working the way it is. Also, this is going to make it harder to get training. I don't know if you realize that most of your instructors out there are NRA certified instructors. There are thousands of them out there, and this would knock that right out. And I do believe that DCJS really didn't want to get involved in trying to create standards and so forth for the concealed carry. But this would really make it hard to get a permit. We oppose. Thank you.
Patricia Webb, Virginia Citizens Defense League. I agree with Mr. Van Cleve. I'd also like to point out, I'm not sure where this 10-round minimum came in, but 10 rounds certainly would not make a competent person with a firearm. However, you don't even need a permit or training or anything to purchase a gun and or open carry a gun. I also want to point out that the NRA is consulted by many, if not most, government agencies for their safety protocols and their range setup and so on and so forth. So taking them out of the qualified instructors is counterproductive. Thank you.
Mr. Chairman, Taylor McKee, National Rifle Association. We're obviously opposed to the bill. We have over 125,000 instructors. More than 1 million Americans have been trained, and we focus on safe and responsible gun ownership. We're the world leader in firearm and safety training, and we have the best and most experienced instructors. For these reasons, we oppose the bill. Thank you, sir.
Anybody online?
Mr. Chair, there's no one to speak in opposition at this time.
Okay. Delegate Hope, back to you. And nothing else?
No, that's all.
Yeah, this one, yes, this one has to go to finance. So Carol Foy moves, Boysko seconds. They'll be reporting to go to finance. Clerk will open the roll.
Ayes 9, no 6.
Delegate, you know I have to explain every one of these on the floor, right?
Yeah. I got you.
At your service.
Okay.
Next up, 798.
House Bill 798, that's right. This bill makes assault and battery and stalking convictions for possession of firearm, prohibiting possession of firearm for 5 years. Obviously, for those crimes that we chose are ones that, obviously, the violent ones that have a complete pattern.
So this just adds stalking and a regular A and B, not a domestic assault and battery, but a regular A and B. So if I were to punch Deeds right now, I couldn't, and I'd get convicted, I couldn't possess a gun for 5 years, right?
That's right. And just to point out, 15 states already have similar prohibitions on firearm possession after violent misdemeanor convictions. 8 of those states impose an indefinite ban, so we're not even going that far.
Okay. Does everybody understand the bill? Senator Perry, light on.
Mr. Chairman, Delegate Hope, this code section, provides a new definition for family member that's not the same definition that's included in 16.1228.
Does.
So it actually excludes certain people. So my question is, we're going to keep firearms from someone who punches a random person at the bar, right? But we're not going to keep them from cohabitating partners under the statute. Is that right?
Mr. Chairman, I know that there's some changes in the definition if you wanted to amend the bill to include that.
Mr. Chair.
Because it picks up 18.257.2, doesn't that pick up everybody under the domestic assault statute?
It says for Part C, it says for purposes of subsection A, family or household member means, and it provides a different definition.
Good point. Yeah, good point.
Mr. Chair.
Yeah.
And Senator Perry.
Taylor.
I did just want to note that, as the chair pointed out, it also does add convictions of domestic assault under 18.257.2. So that would pick up any assault and battery of any family or household member for assault and battery under 18.257.2.
So Taylor,
Mr. Chairman.
I think Senator Perry's point is that because subsection C creates some conflict there, right?
That's exactly right.
But, Mr. Chair,
Yeah, Senator Deeds.
I just wonder why subsection C, that definition is still needed.
If we're going to pick up all of household and family member, then subsection C should be eliminated.
Right.
Mr. Chair.
Yeah, Taylor.
There just may be some complications with the dates because the new language is prospective only. So if we wanted to keep people from possessing firearms who are convicted of the assault and battery of family household member as defined here after July 1st, 2021, just maybe something to think through.
Right, because you're saying it can impose a retroactive consequence on somebody who was already convicted before July 1. Yeah, Senator
Chair, I
Deeds.
think that can be fixed with an enactment clause.
I think so,
that says
too.
This is effective for all offenses. That definition counts with respect to all offenses that occur prior to the effective date of this legislation.
Right.
Prior to July 1, 2024.
Right. So, Taylor, can we do that? Or
Mr. Chair, I may have to think it through because it could end up just so if the definition had to stay, then it may just be how it's currently drafted, where the definition applies to convictions on or after July 1st, 2021. Or is that definition of family or household member, and then the new subsection would cover conviction of assault and battery of any family or household member if it was after July 1st, 2024. but I can still try to think through it. It's just, I think that's why it's drafted that way currently.
Okay, but it sounds to me like it might be a little more tricky surgery than.
I'll talk, Mr. Chairman.
Yeah, Senator Perry.
I'll talk to Taylor May after this.
Okay.
And
It has to go to
Delegate Hill.
finance? Okay, so here's what we're going to do. We're going to do some surgery and have a sub for finance. Okay? And Perry and May and Hope will work and figure it out. All right? So with that understanding, we need to take testimony, I think, right? Yeah, we haven't taken testimony. So 3 and 3.
If there's anyone online that would like to speak in favor, raise your hand.
Good morning, Mr. Chairman, members of the committee. My name is Lori Hoff. Data and research show that persons who commit violence are at an increased risk of future violence. This is a temporary prohibition. It gives people a timeout. It gives the system a chance to work. And we know that, and it includes an automatic restoration after 5 years. We think this is a narrowly drafted bill. It makes sense, and it works for those who have committed harm and committed violence to be prohibited from owning a firearm for 5 years. Thank you.
Mr. Chair, we have one person online to speak. Kendall, you may unmute.
Thank you, Mr. Chair. Kendall Jacobson, Everytown for Gun Safety and Moms Demand Action. We support the bill. There was a recent study that nearly 9 in 10 murders of women were preceded by an incident of stalking, and so in particular, we want to congratulate the sponsor on including that. Thank you.
Great. Let's reset the clock. Opponents, come on up.
If there's anyone online that would like to speak in opposition, raise your hand.
Philip Van Cleve, VCDL. Unless I'm mistaken, this also picks up simple assault.
It does.
Doesn't even require the battery part of this, simple assault.
It does.
Yeah, that's anyhow. We don't think a misdemeanor should be taking away your rights to begin with, but certainly not simple assault. Thank you.
Good morning, Mr. Chairman. Patricia Webb. Just to reiterate what Mr. Van Cleve said, simple assault could be yelling at someone, and they turn around and run into a wall and hurt themselves.
That is not the law. That's not the law.
There have been people convicted of assault for similar things.
They had bad lawyers then, because that's not the law.
Thank you for your time.
Mr. Chairman, Taylor McKee, National Rifle Association. We're opposed to the bill for the reasons stated previously. We also don't think gun rights should be taken away outside of felonies and mental adjudications and concerns with due process. Thank you, sir.
Thank you. Anybody online?
Mr. Chair, there's no one to speak in opposition at this time.
Okay. Okay, it's been moved by Deeds and Boysko, moved and re-reported to Finance. Clerk will open the roll.
Ayes 9, noes 6.
Okay.
Last bill, Mr. Chairman. House
All
Bill
right,
799.
last one of Hope-a-Palooza.
Last bill just says that when you apply for your concealed handgun permit application, you have to include fingerprints.
Sorry, say that again, Delegate.
Person to submit a fingerprint for a condition of obtaining their concealed handgun permit.
Wasn't that the law? Wasn't that the law 5, 6, 7 years ago? It's 8 years ago.
Maybe, but the whole point is that to make sure that the person that's applying with their name and social security number is actually that person putting in the application.
Okay. I think it used to be the law. I think. Okay.
Mr. Chairman?
Yeah, Senator
Can we
McDougall.
include that for voting?
No. Yeah. Usually, voting usually isn't deadly. That's right. Okay.
Permits are privileged.
Why don't we set it 2 and 2? Come on up in favor.
If there's anyone online to speak in favor, raise your hand.
Mr. Chairman, Andrew Goddard, Virginia Centre for Public Safety. This was, in fact, the law. It was the law when I got my concealed handgun permit. And so I think it's a good idea to make sure you absolutely know who someone is. They can change their name, they can change all sorts of things. They can't change their fingerprints. Thank you.
Good morning, Mr. Chair, members of the committee. My name is Lori House. We support the bill. That is a simple thing to do. We've done it for years, and we need to go back to it to to avoid identity theft and persons trying to impersonate someone else and avoid the law. Thank you.
Mr. Chair, we have one person online to speak. Kendall, you may unmute.
Everytown.
Thank you, Mr. Chairman, members of the committee. Kendall Jacobson, Everytown for Gun Safety, Moms in Action. We support the bill.
Thank you. Okay, let's reset the clock.
If there's anyone online to speak in opposition, raise your hand.
Philip Van Cleve, VCDL. As been stated, there was a time when we required fingerprinting. The state police at some point said, look, we really don't need to be doing this. And so fingerprinting was removed. And again, I think this is a problem, a solution in search of a problem. Where is the issue with any of this stuff? I believe there is one. We are strongly opposed. Thank you.
Hey, Ms. Webb, sorry I snapped at you a minute ago.
Understand. Thank you. Patricia Webb, Virginia Citizens Defense League. I would question the patron if there's actually been any instance of somebody actually pretending to be somebody else and getting a concealed handgun permit. We removed this several years ago because, as Mr. Van Cleve said, it was unnecessary. It's also a burden on our law enforcement agencies. Most people go down to their local sheriff's or police department to get their fingerprints run, and it just puts extra time, need for personnel on them. There have been no problems since this law was repealed. As a matter of fact, a few years ago, we repealed the need to have the form notarized. You have to submit a copy of your driver's license with your permit application. So that is proof that you are who you say you are, unless the DMV got it wrong. Thank you for your time.
Thank you. Anybody else? Anybody online?
Mr. Chair, there's no one to speak in opposition at this time.
Okay. The last bill, Hopapalooza, is before us. Is there a motion? Okay. Perry moves and Carol Foy seconds. The bill be reported, be referred to Finance. Clerk will open the roll. All right.
Ayes 9, no 6.
Thank you, Mr. Chairman.
All right, there you go, Doug. Hope. Okay, next. Why don't we go back to Kent? We made any progress on your jet ski?
One they didn't, and some Dominion's bad.
Who wants to tell us what the proposal is? Because I'm not sure it's necessarily in clear water, but
no pun. The staff was very helpful, so thank you for them to help us add code language.
Yes, Mr. Chair. So the subsection D would be changed to read, a conviction for a first offense of this section shall be punishable by denial by the court of such person's privilege to operate a watercraft or motorboat for a period of 1 year, and then the same language for the second or subsequent offense, but for a period of 3 years.
okay, so we're only limiting it to your boating license, no other licenses.
Mr. Chairman, I
Yeah,
think
Senator McDougall.
I think Taylor grabbed that from the DUI boating statute, so it's already existing language.
Okay, but we're just limiting
That's
it to
correct,
boating
Mr. Chair.
licenses, no other licenses. Senator Bagby has a question, I think.
Mr. Chairman,
Senator McDougall.
technically, you don't have a boating license. You have a privilege to operate a boat, so there's no actual physical license.
I thought we passed a law, the feds made us pass a law a few years ago that says unless you're grandfathered, you have to have a boating license.
You have to take a
course.
course.
Okay.
And so you might have to have documentation of completion of the course, but it's not a license.
Right. Okay, Senator Bagby has some stuff. Microphone. Mike.
It waters the bill down. I'll have to oppose the amendment.
Makes it fishy too, huh? All right. So Senator Bagby doesn't like it watered down. But I think the patron thinks it's a friendly amendment, right?
I'm happy to do what passes the bill that the committee can help us
Okay, so
to come to consensus for unanimous
I think
support.
McDougall moves the amendment. Stewart seconds it.
I ain't seconding it. I do.
Okay, Obenchain seconds the amendment. The waterman rights guy over there doesn't like it. Okay, all those in favor of the amendments say aye. Aye. Anybody oppose the amendments? No. Okay, MJ, why don't you open the roll on the amendment? Wow, look at that. Wow, look at that. What is that?
Ayes 7, noes
Wow.
8.
Wow. Look at that.
Move to report.
Second.
Okay, well, there's a motion to report the bill as amended, and it does not need to go to finance because it's a misdemeanor. Not amended. Not amended. Not amended. Might not be the last you heard of that. Clerk will open the roll.
Ayes 15, no zero.
We might be seeing that amendment on the floor, I think. We'll see.
Thank you, sir.
Thank you, Delegate
Committee, I
Kent.
appreciate your help. Thank you
Yeah.
so much.
Okay, next, Clark. McClure, do you have a 10 o'clock? Okay, I know Clark does. I want me to get him out of here. So McClure's next, but Clark has a commitment. So Clark, you've got...
I got two bills.
You have two?
Yes.
35, firearm safety device tax credits.
Thank you, Mr.
We
Chair.
do not see many tax credit bills in this committee. So you want to expand the tax credit for firearm safety devices?
Yes, just to include, to expand it to trigger locks, to expand the definition of safety locking devices to any, to include trigger locks in what's already existing.
Okay, does anybody on the committee have any questions for?
Mr. Chair?
Yeah, Senator Obenchain.
The gun safe tax credit was wonderful, a wonderful help to me in Christmas shopping last year. So I thank you for expanding my shopping list for this year.
No problem.
Anybody else have any thanks they want to give to Delegate Clark?
Mr. Chair,
Senator Deeds.
the only thing I'll say is this is not a bill that's on the list to go to finance.
That's bizarre.
And that just, you're talking about gun locks, you're not talking about things that really cost a lot of money. So it's not going to have a significant impact on the budget. It's
Same amount, same cap. It's just adding something else.
Yes, the fist that I got back said it doesn't need, it doesn't
Okay.
have a budget.
All right, anybody opposed the bill?
If there's anyone online that would like to oppose the bill, raise your hand.
Nobody's opposed. Okay, Senator Perry moves, Salim seconds, the bill be reported. Clerk will open the roll. All right, Clark, wait a minute.
Ayes 15, no zero.
Clark, next one, you reported. 351.
Yes.
Locking devices required for the purchase of firearms where children are present.
Yes, Mr. Chair.
Whole new statute here.
This bill would just simply make sure that when you purchase a firearm, when you fill out your form, it will now have a question up there that says, do you have a child or minor in the same home? If you select yes, then you will have to purchase an accompanied trigger lock or locking device with that purchase. In violation of this would result in a Class 1 misdemeanor.
All right. Let's see. So, Delegate Clark, have you talked with Delegate McClure about her bill? Because you guys are kind of similar shades of the same problem here. Have you guys talked about whether there's any possibility of combining your bills? Or
Yes, she actually, Delegate McClure had, we conformed her bill with Delegate Jones' bill when we were still in the House, and we let this bill take a different route just because it does deal, it's slightly different but also similar, as you pointed out. But this bill in particular will just create that affidavit when you are filling out when you're purchasing a firearm to make sure if you do have a child at home. It's only if you have that minor present when you fill out the form that you will have to buy the company.
Right, but her bill basically makes it illegal for a
manufacturer, seller.
Right, but it makes it for a licensed dealer to sell a firearm without a locking device. And yours makes it illegal to sell it without a locking device unless somebody certifies they've signed an affidavit.
Yes.
Right? So, I mean, it's not clear to me you can have both policies moving forward at the same time because they're a tiny bit inconsistent. And so that's why I'm asking whether you guys have talked about putting your bills together. We can't pass two bills that do two different things on the same topic. Have you guys talked about that? Senator Deeds, do you have something you want to say?
I was just going to say, in terms, Delegate Clark's bill makes it a Class 1 misdemeanor. Delegate McClure's bill makes it a Class 3 misdemeanor. They're inconsistent. I'm not sure why the House would pass two totally inconsistent bills.
Right.
They just need to figure out which is the best policy.
So you guys want to go talk to each other over the next couple days and figure out if there's a way to combine your bills or combine approaches? It seems to me there's pieces of both that could be put together into one in some way. But what? Is it today? Is that today? Deadline's today?
Mr. Chairman.
Yeah, Mr. Benjamin.
One potential problem I see with the swearing that you don't live in the same home as a minor, although this is a misdemeanor, if you falsely certify that you don't live in the same residence as a minor, then that could be prosecuted as a felony. And depending upon the adequacy of the state police form definition of residency. So, for example, if you have joint custody and a minor lives with you a certain number of days out of a week or a month, then it's ambiguous whether you have a minor residing with you, because residing indicates a continuous period. And I'm concerned about people inadvertently subjecting themselves to a prosecution for false certification by the state police.
Right. So, counsel, I guess what you're saying is that maybe if a child is spending the night at a grandparent's house for a period of time, grandparent knows the kids come over every once in a while, they in theory could have some exposure under the affidavit.
I don't think that would do it, Mr. Chairman. I looked for the definition. A Court of Appeals, the most recent Court of Appeals definition of residing I found was the act of abiding or dwelling in a place for some continuance of time, which begs the question, what is a sufficient continuance of time? How many days, for example?
Yeah, I have some child custody litigants that don't think 3 days is a substantial period of time, but some judges think it's plenty, so. Okay. But we have to act on this today. Delegate McClure, you have something you want to say? Because we also have your bill next in the queue, and you're kind of on the same
Mr.
subject.
Chair, and if the patron is amenable to this, I don't mind rolling mine into his, and then if he wants to take my language, just wanted to put that out there.
1 second. We allowed to do that on House bills? Yeah, House bills, that's not allowed. We can carry yours over, and then we can take your language and stick it in. It's not, and we can, but we can't make that motion.
Yes, Mr. Chair, I'm okay with that.
But we'd have to figure out how to do that surgery between now and finance, I think.
Well, let's pass vote on these bills.
I got it. We're working on it, Pete. Got it. We're getting there. So I got it.
I'm open to that as well, Mr. Chair.
Okay.
Mr. Chair,
Deeds, yeah.
I would just suggest that if we think this is a Class 3 misdemeanor instead of Class 1, we can let these parties work it out over the next couple of days, and we won't have to send it to finance. Understanding today, if the day passes, we're not going to.
Yeah, that's the only reason it's going to finance is the felony, the swearing, right?
Yeah.
Yeah. Okay.
Oh, yeah, Mr. Chair, I was going to note it goes to finance 1 because it's a Class 1 misdemeanor and gets picked up by the third conviction of firearm misdemeanor makes a felony and the penalty of perjury statement. So for 2 reasons.
Okay, but Taylor, if we make it a Class 3 misdemeanor, is it still the third offense still kick in?
That would not kick in if you make it a Class 3, but you'd still have the felony for the perjury statement.
Okay, so I think Deeds' strategy, I think, makes some sense. That way we can deal with this Wednesday. You guys do some surgery, bring it back Wednesday. You're not going to get whacked by the finance deadline if you're okay with a Class 3 misdemeanor.
Mr.
Delegate
Chair,
Clark, you okay with that?
The only reason
Okay.
I suggest that is this is something that should have been worked out on the other side. We shouldn't have to deal with inconsistencies between House bills.
Okay.
I'd rather let you all figure it out and then
Okay.
come up to us with one approach.
Okay, so can you guys, over the next 3 days, go talk to each other, figure out how to make a combined bill, Class 3 misdemeanor? It won't matter whose bill it is because we're not going to finance anymore, okay? Senator Stewart.
I listened to Mr. Benjamin. Did I misunderstand what he was saying, that it's already a felony if you misstate something on that form, and this would contradict
No,
With
the
the
form
class
is
one
new. The
misdemeanor.
form is new. In the bill, the form is new.
Well, how do you jive this with the felony
Here's to it.
that they charge you with if you misstate something on the form?
Mr. Chairman, that's right. This doesn't create a felony.
No, it creates a misdemeanor.
It creates a misdemeanor, but, and I'd like to be corrected by the CAs if I'm wrong, I think that the typical prosecution for making a false statement on a firearm purchase form is prosecuted as a felony.
It is in fact a felony.
That's correct,
There-
Mr. Chairman.
There's no question about that. And
That's
so
correct.
now you have both a misdemeanor or felony offense, and that doesn't jive. Thought that's what Mr. Benjamin was pointing out to the committee.
Yes.
So you've got a bigger problem because you're actually, if you want to do it, you're actually lessening the offense.
Right, but Senator, I think you could do it without the form. I think McClure's bill doesn't have a form, it just has a warning, I think. And so you could have it, as long as you don't have the form, then you don't have the felony problem, right? So, Mr. Benjamin?
Mr. Chairman, one possible solution would be to make it a definite period of time. And so you might say whether a person resides more than X number of continuous days within any calendar month. That way you have a definite period of time establishing what constitutes residency for purposes of this bill. That would be a solution if the committee chose to go in that direction.
Delegate Clark. I would suggest you go rewrite a bill as a Class 3 misdemeanor with no form whatsoever. Get it out of here. If you don't like it, go to conference.
Yes.
Got it? Okay, so without objection, House Bills 351 and 158 will go by for the day. We'll hear them again Wednesday, and hopefully there will be no felony associated with them, because then we'll be in trouble with finance.
Right.
Got it?
Yes, sir. Thank you,
Okay.
Mr. Chair.
All right. Great. Now, I have oh, you have another one?
Yes. Mr.
Oh,
Chair.
okay. Hold on. Let's see.
It's HB 893.
893, representation of parents in child dependency cases. 893. Go ahead, Delegate.
Thank you, Mr. Chairman, members of the committee. HB 893 increases compensation rates for court-appointed parent counsel in child dependency cases. This bill also directs OES and the Virginia State Bar to create standards of practice for court-appointed parent counsel. Once these standards have been established, the courts will have access to a new list of practitioners who are trained and qualified to represent parents in child dependency cases. Lastly, this bill allows localities to draw down on the federal funding to develop and oversee pilot multidisciplinary law offices with folks who are trained and qualified to represent those parents.
Is this like child support cases?
No, this is not. Yes.
Yeah, what are child
Mr.
dependency
Chair.
cases?
This is when it comes to termination of parental rights
Got it.
or anything related to foster care.
All right. And did the House include more money in its budget for that?
Did, Mr. Chair.
Okay, we did not, but it was my amendment which didn't get accepted. So we'll see how you do in finance. But okay, this is generally a good idea. I mean, right now they pay parents $120, or they pay lawyers $120 to defend people in a.
That is correct, Mr.
Right.
Chair, for child dependency cases and 158 when it comes to termination of parental rights.
Got it. Okay. Does anybody have any questions for Delegate McClure? Okay. I know there's some people in support over there at Poverty Law Center, or right? Yeah. Yeah. I know you guys have been passionate about this in the beginning. Is there anybody opposed to the bill? I think this is mainly a finance question more than anything, right?
If there's anyone online that would like to speak in opposition, raise your hand.
Okay. Is there a motion? Okay. Perry moves. Carol Foy seconds. Bill be referred to finance. Clerk will open the roll.
Ayes 15, no zero.
Thank you, Mr. Chair, members of the committee.
Thanks for waiting around. Okay, next up we have Converse Fowler, who's been waiting patiently. Yep, she's on the list. 1380. Oh, I'm sorry. And Webert's up there too. Yeah. All right, we'll get to you guys. Two left after this. Converse Fowler. Go for it. Workplace rules of localities.
Thank you, Mr. Chair.
House Bill 1386 is just a simple way, a few years ago, when we passed the local option for localities to ban firearms within their buildings. And this is just a cleanup of the section that allows the localities to put workplace rules in place for firearms. And this just says that if the locality does choose to restrict firearms in their buildings, that the rules for the employees cannot be less restrictive. So they cannot allow them to bring them in. It has to be on the same level as those with the public rules that they do put in, if they do choose to put those in place. In a nutshell, Mr. Chair, that is what the bill does.
Okay. Is there any opposition to your bill?
If there's anyone online to speak in opposition, raise your hand.
Doesn't look like it. Did your locality request this, or no?
No, but it does, Mr. Chair, it does come from the idea of the mass shooting in Virginia Beach that happened where if the locality does choose to ban firearms, it would need to be on the same level with employees because it wasn't an employee.
Okay. And so if a locality does not choose to ban firearms, then could they adopt restrictions on their employees in their buildings?
Yes, Mr. Chair, they can.
Okay. All right. Senator Perry has a question.
Mr. Chair, I just have a question. The example that you gave initially was that if a locality bans firearms, right, then the wording of this that is that the workplace can't have less restrictive rules, but I'm not quite sure how the workplace could permit firearms if the locality has decided to ban them. How could it be less restrictive would be some permission for firearms?
Mr. Chair, so I would say that if the code section is written in this section that it allows, and the council might be able to answer this better than I can, but in that section it does talk about how they're allowed to put rules into place for their employees about firearms, and this just says, well, if they go ahead and do the local option, whatever rules they put in place under the local option, they would also have to address if those employee rules are more restrictive. They would need to be the same, or they can't be any more less restrictive, which is really confusing language, but we did work on, and I think council could clarify, Mr. Chair.
So, for example, if the locality adopted a rule that said you can bring a gun into a building if you have a concealed weapon permit, they couldn't prohibit their employees completely from bringing it in if they allow the public to come in with a concealed weapon permit, right?
Well, right now, Mr. Chair, they can allow right now as a default, firearms can be brought in unless they adopt the local option, unless they adopt the rule. So if they haven't adopted the rule, but in Virginia Beach, for example, they have not adopted any additional rules for the public, but their employees are they said they can't bring their firearms into work.
Back to my yes or no question. If the locality says you can come into a public building with your gun if you have a concealed weapon permit, the locality cannot have a different rule for employees that says they can't bring it in at all.
No, I believe they can, Mr. Chair. Council could probably answer.
And Mr. Chair, yes, I would just point out, it says that the workplace rules can't be less restrictive.
Okay, so they
Not more restrictive.
can't go the other way. Okay, so it can't say that the employees can bring it in without a concealed weapon permit.
Yes, Mr. Chair.
Got it. Okay, sorry. Okay, any other questions? Nope. Okay, nobody seems to be opposed. Been moved to report. Seconded, the bill will be reported. Clerk will open the roll.
Ayes 9, no 6.
Okay.
Thank you, Mr. Chair.
Thank you, Delegate. I have Webert, who I skipped unintentionally, and then Munden King, you're last. And that's not intentional, Delegate Munden King. It's just my sign-up list. All right, Delegate Webert, what do you got? 1427, sexual battery, suspension of sentence.
What the bill does is it came out of the House, Mr. Chairman, is it would extend the maximum length of probation for 2 misdemeanor offenses, sexual battery and then sexual abuse of a child between the ages of 13 and 15. Both of these offenses are Class 1 misdemeanors with a period of 12 months. What the bill does is it could lengthen the length of probation for these offenses under this bill would then become a maximum of 3 years. Where this would help is in cases where no court-ordered program occurs as part of the sentencing, or if a court-ordered programming would not last as long as a judge believes is necessary. It's kind of an in-between step.
So this just says, so typically this would be a 1 year
Yes, sir.
period of suspension. You want to make it 3 for,
If the judge so chooses, sir.
got it. Okay. Anybody have any questions for Delegate Weber? Let's see. I don't see anything there, do you? No, I don't see anything. Okay. Anybody opposed, support? Vaca, looks like you wanted to say something. You good? Oh.
Sorry,
Oh,
we do
come
have-
on up.
If there's
Yeah.
anyone online to speak
Sure,
in
2 and
favor,
2.
raise your hand.
Come on up. Welcome.
Chairman Serval, members of the committee, good morning. My name is Rowan Danielson. I'm 14 years old and an 8th grader living in Farmville, Virginia in Prince Edward County. I'm here with you today to speak in support of House Bill 1427. In late December of 2022, I was riding my bicycle home from downtown Farmville, and after getting to the summit of a long hill, I stopped on the side of the road to catch my breath. A van that wasn't in good condition passed me, stopped, then reversed, then pulled close beside me. The man inside offered to put my bike in the back of his van and to take me home. I declined politely, and thankfully for whatever reason, he moved on. I rode straight home and contacted my parents. My dad drove us back to where the incident occurred, and we went looking for the van. By a stroke of luck, we located it, photographed the license plate number, and reported it to Farmville PD. Later, we learned that this man couldn't be violated or charged for this incident because his probation was limited to just 1 year, and even though he was very recently, he had been charged with 4 prior felony sexual offenses against children, all of which were pled to misdemeanors. We also learned that he had been incarcerated several years earlier for at least 1 other felony sexual offense. For this offender, clearly, being off all rules after 12 months was not enough, and I think there are many other sexual offenders in Virginia who need at least some accountability for being beyond 12 months, given the seriousness of their past offending. Therefore, I respectfully urge you to support HB 1427, and please accept my thanks for your time and listening about my experience. If you have any questions for me, I am happy to answer them, and if not, I wish you all a good rest of your session.
Great. Thank you. Thanks for coming and testifying to us today.
Yeah, Nathan Green, Commonwealth Attorney for Williamsburg, James City County. VACA is in support of the bill as well. Happy to answer any questions you may have.
Okay. Thank you, Mr. Green. Okay, is anybody opposed to the bill?
If there's anyone online to speak in opposition, raise your hand.
Doesn't look like it. Okay, Deeds moves, Boysko seconds. The bill be reported, and it does not need to go to finance. Straight to the floor. Clerk will open the roll.
Ayes 15, no zero.
Great. Thank you, Doug Weber.
Thank you, Mr. Chair.
All right. Last but not least, my former constituent who can't vote for me anymore, thank God, Delegate Munden King. Right? She might not be voting for me next time after that wait. I'm sorry.
Thank you, Mr. Chair. I definitely feel the difference now that I am no longer your constituent. Thank you, Mr. Chair.
Well, you got Carol Foy now. She'll take care of you.
Yes. House Bill 585 is a bill that comes to us that many folks have said is a little unbelievable that I've had to even bring this bill forward. But what this bill simply says is that if you're operating a home-based firearm business, that you cannot do that within 1.5 miles of a school. This is something that came to me directly from my community where this has become a problem in the vicinity of 2 schools that you used to represent. And the community as well as local individuals have asked for state clarity on where they can regulate the zoning of these types of gun businesses.
Okay, anybody have any questions for Delegate Munden King? Nobody? Okay, is there anybody? We know you support the bill, Ms. Haas.
Yes, thank you. I'll be very brief. Just to point out that most school systems have a minimum under which students can ride a bus, and that minimum is often 1 mile, 1.5 miles, sometimes longer. So those students are walking. It's not just, so this makes a lot of sense. The distance that the delegate arrived at, we support the bill. Thank you.
Thanks. Okay, is there anybody else in support? Nobody online? Okay, opposed? Come on up.
Philip Van Cleve, VCDL.
This makes it seem like guns are kind of cooties. You know, if you're within a mile and a half of them, they can infect you somehow. They have 7-Eleven stores that can sell all vape products and alcohol, and they even have some magazines with some risque covers on them that these kids could go to that are well within a mile and a half. We're not worried about that, apparently. Also, the people that will be doing these, that run these businesses, a lot of them are simply doing background checks, which are required for things like universal background checks or buying a gun through the mail or over the internet. They have to be shipped to a dealer. These dealers fill that goal. You're going to wipe out most of them. If you draw a map of everywhere, we have one of Richmond. And it's like there's one little tiny corner that isn't within a mile and a half of a school somewhere. So we strongly oppose this.
Mr. Chair, Taylor McKee, National Rifle Association, we oppose the bill for the reasons stated. Be detrimental to the industry. Thank you.
Thanks. Ms. Webb.
Good morning, Mr. Chair, members of the committee, Patricia Webb. This amounts to zoning prejudice, basically. So if a business falls into a certain classification and that classification is allowed in a certain zoning area, then what this bill is saying is that all but this one type of business, and it's not even FFLs in general, it's home-based FFLs. This would put 1,600 FFLs out of business, people that provide valuable services. I will point out that the bus stopped right at my gun store, which is a mile from a school, but I'm a brick and mortar store, so this wouldn't affect me. If I moved it into my house next door to my gun store, it would affect me. And what's the difference? So I urge you to oppose this bill and stop the prejudice. Thank you.
Thank you, Ms. Webb. Senator Deeds has a question.
Ms. Webb, you said 1,600. Where does that information come from? Is there a way for any of us to check to see that?
Mr. Chair, Senator Deeds, I can email you a chart. I did not bring it today, unfortunately, but it was a mapping service that was pointed out by one of our members and sent to us. They mapped the schools and they mapped the zone around the schools and they mapped home-based FFLs. And it worked out to a little over 1,600 FFLs that would be put out of business by this.
Okay, Delegate King, I want to ask you, I'm looking at the definition of residential zoning district classification. If this lady had, and she was an R1 or R2 and had a special exception for a building with a, that was outside of her home, that was next to her home, even though she had a special exception, would that still be restricted because she's in a residential zoning district classification?
I think
So-
she grandfathered initially, but.
So, Mr. Chair, I would say that in my conversations in drafting this bill, because of course I do not want to bring harm to any businesses, it is simply to protect communities like mine. I asked if this would automatically put anyone out of business, and counsel on our side assured me that it would be, that answer was no, that those 1,600 businesses would not be automatically put out of business, but that the locality could then review the zoning based on the state policy. But to answer your question directly, my goal is purely residential areas, because you make a decision. If I wanted to live near shops of any kind, then that's a different, mixed use zoning in my community. But my goal is for purely residential. So in her scenario, I would imagine if she lives next to a brick and mortar gun shop, that it would be a different zoning than purely residential.
And Mr. Chair, this wouldn't apply in localities that don't have zoning.
I'm sorry?
This would not apply in those localities that don't have zoning.
I don't think so. I'm not sure, though.
Okay, thank you.
Great.
Thank you.
Okay, it's been moved and seconded. The bill be reported. Clerk will open the roll.
Ayes 9, no 6.
Great.
Thank you.
Thank you, Delegate London King. So,
All is forgiven.
thank you, Delegate. So, ladies and gentlemen, that means we've got 26 down today and I think that means about 31 to go in 2 meetings. So that's where we stand. The committee will rise.
The Senate of Virginia.
Richmond, Virginia.